stand up. Make sure your phones are on off or in silent.
Yes. Yes. Yes, I did.
And please, no recording or taking photos. If you need to use your phone, step outside.
Computers are working slow today. All right, everyone, happy Monday. Today, as Gracie's Corner says, today is going to be a great day because it's new beginnings. All right, I'm going to call the docket. When I call the docket, you need to let me know you're here. If you don't answer, I'm going to assume you're not here and a warrant may be issued for your arrest. In custody, we have Adrian Arias, Justin Stegmeyer, Arturo Aguilar, Jason Golfo, Xavier Garcia, Adrian Garcia, King Alvarado. In custody, we have Terrence Reed, Jerson Rodriguez, Jorge Macias Castro, Pedro Sanchez, Fabian Cardenas, Patricia Ann Lopez, In custody, we have William Chapman, Gina Garcia, JC Laday. Is that pronounced correctly? Okay. Brandon Sierra, Hannah Smith, Caleb Coleman Lee, Coleman Lee. He's supposed to be by Zoom. Theda Reyes is in custody. Anthony Miller. Jamaria Simmons. Where? In custody is Bernardo Huerta, Christopher John Reyes, Christopher Edwards in custody, Roger Gonzalez custody, Tony Banks, here. John Meyer, Jonathan Chamez is in the hallway with his attorney, Tanya Lopez. In custody, we have Theda Danasuk. Hopefully I'm pronouncing that right. John Marino. In custody, we have Vanessa Varela. Ronnie Simmons. Mason Smith. In custody, we have Mark Ramirez. Naran Alexander. Andrew Pena.
Here you are.
Juan Davila. In custody, we have Carlos Madrigal. All right, is there anyone who came in late or your name was not called? Yes, what's your name? Timothy. Do you know who your attorney is? Who's there with you? You mean the mother of your child? All right, so the mother of your child is not in charge of knowing who your attorney is? All right, you should know that off the top of your head. But so check on your phone, who's your attorney? And how old is your child? And who is with this child while the mother of your child is here in court? Yeah, I don't think your mom signed up for that, but okay. Anyone else? All right, everyone, these are the rules of the court. I try to keep the center of the courtroom as least congested as possible. So attorneys, you'll see files here, files there. Those are the prosecutor's files. Just pull your case file, place it on the desk, have a seat. Prosecutors will call you when they're ready to confer with you. Do not approach the court if you have not conferred with your client and conferred with the state. If there is an offer that the state has not been able to tender to you, I need to know that. If you have a client who's in custody, request that client from the deputy. I want all clients who are in custody before the court, before we do anything. So please do not approach and say, we're getting a reset, because I'm the only person who can give resets. I'm the only person who can give continuances. So do not approach the coordinator asking for a continuance or asking for a reset. I'm the only person who can give you that. It's Monday. Today is going to be a great day. Put some patience in your pocket, take it out as needed. To the fellas, you end up having more pockets than the ladies because I know you have the secret pocket on the inside of your suit coat. Give it to somebody if you see them having a slightly bad day. All right, so it's going to be a great day. Please confer. Hi, good morning. Oh, here's some right here. And then the deputies have some as well. Good morning. I might get taken up to it. All right, Juan Davila. Oh, no, he broke his kneecap.
Yes. So it'll just take 1 second.
Hello. I'm sure breaking of your kneecap was painful. So what is the prognosis?
But I got arthritis in both knees. It's, my
Meniscus. Yeah.
Lift on me, so I need surgery.
Oh. And so this is what people need to realize. When you see professional basketball players and they say they have a torn meniscus and people are like, they get paid $10 million. Why are they not playing? Now you know. Yes.
Everything.
All right. So two things. And I know this is ex parte motion, but you didn't tell me in it how much money you will be requesting. Yeah, that needs to be in there.
Okay.
And I need to, because is this for just an investigator?
I believe so, Your Honor.
Okay.
It was one of our other attorneys that had drafted the motion. But yes, we were trying to get an investigator for medical issues for the complaint.
Oh, medical for the complainant?
Mhm.
All right, could I see the prosecutors on Juan Davila, please? I don't know if this is criminal trial division or family violence.
I believe it should be CTD.
All right. Yes. On this case, I guess there's some medical reports you need
We have them, Your Honor. We just want our investigator to review them.
to review medical reports.
Yes.
Okay.
Yeah, okay.
So state, has an offer been tendered in this case?
I don't remember, for the last couple of settings, we've been working on the medical records today, so I don't.
There was a lot of discovery issues. I think we did finally get that resolved, and now we're just working on trying to build our case for trial. It's my understanding. We're just trying to get an investigator to look at some of the medical records.
All right. So I'm assuming that you all are not planning on going to trial without an offer being tendered.
No, we just haven't got one yet. I don't believe so.
All right.
Yes, sorry. Yeah, I don't see it.
So state, when are you planning on making an offer? Because we were here on February 2nd and we came back. Oh, we're supposed to come back already on March 9th for the state to make an offer. So,
We were just here for the.
Oh. so state, you'll be prepared to make an offer on March 9th?
Yes, Judge.
And you say all discovery has been received?
Yes, Your Honor.
All right, state, if you can do an acknowledgement of discovery.
Sure did.
All right, and I'll put your order within what's in the guidelines. If more is needed, then just reapproach.
Yes, Your Honor. Thank you.
You're welcome. And do you need a reset form for March 9th?
Yes.
All right, Ms. Ferguson, if you can give him the reset form for March 9th, it's already in the system for March 9th.
Thank you, Judge.
You're welcome. And if you need a copy of the order, they will get a copy to you.
Thank you.
Jonathan Thomas. Xavier Garcia. Ronnie. Simmons. Juan Moreno. Taylor.
Christopher Edwards.
You can go.
All right, was he brought over?
I think you will. Yes, Mitch.
All right, could you have him come out?
Okay, Mitch.
All right, thank you.
Taking chair. We're taking one. Taking chair. Taking chair.
Yeah, you know.
What down?
Who's here on King Alvarado? All right, and where's Mr. Alvarado? And counsel your clients in the middle.
Yes.
All right, what is happening on this case?
Your Honor, this is our first court setting. I do understand it's a 2019 case. However, my client was not served with the at-large warrant because he was in federal detention in another state. So we just recently were released from federal detention. We've been served a copy of the
Could
indictment.
everyone please whisper? So he's been released from federal detention?
Yes, ma'am, and he's been bonded out on your charge.
All right, and why was he in federal detention?
He was serving a sentence for a federal case. Smuggling aliens.
Okay. And is he on supervised release or no?
Oh, I'm sorry, it was a drug case. I think.
Oh, so it was drug case?
Sorry, Judge.
No problem. And is he on supervised release?
Yeah.
And how long are you going to be on supervised release?
2 years.
All right, do you have all the discovery?
I believe so, Your Honor.
State, were you able to tender an offer?
Not at this time, Judge. I am taking a moment to review the case, but I have put Ms. Carl, I will be.
All right, Ms. Ferguson, if I could have a 30-day reset on Mr. King Alvarado, please.
You can come back on April 1st.
All right, we're going to see you back on April 3rd. State at that time you'll need to be able to tender an offer. And thanks for dressing appropriately for court. Ms. Ferguson will give you a reset form, then you're excused. You're
Thank you,
welcome.
Your Honor.
You're welcome. Vanessa Varela. Yes, come forward. All right, defense.
I've been unable to confer with my client, tried on the Zoom and here today. I'm filing a motion for competency this morning,
Okay.
so we'll need a little time to do that.
All right, Ms. Ferguson. On Ms. Varela, can you give me a 45-day reset? All right, so we'll come back on April 13th. That's to see where we are with regards to competency. I know they're a little bit backed up.
Okay, no problem.
All right, Ms. Varela, do you have any questions? Okay, all right, thank you.
Thanks, Glenn. All right, Vanessa, I'll see you in a few, okay?
Oh, Meredith, how's your daughter doing?
She's actually at the neurologist right now. She's doing a little better. She's been taking the bead.
Mhm.
And she was just doing a follow-up. She's doing a little better. She got a job, a little
Oh,
part-time job at the school. So
okay, that's awesome.
that's good. We'll
Yeah.
see, you know.
Oh, yeah, I think they're gonna discover something about these migraines, because it seems like now everybody is getting like real serious migraines.
We're gonna go to an immunologist and have some tests done to see if she's got an allergy trigger or, you know what I mean? Like, we're trying to come at it from every,
Oh, yeah,
but so she's got a lot of doctor's appointments.
yeah, because I told my mom, I said, we're gonna write down everything, and of course, my mom doesn't like journaling, because it's like, I gotta stop and write down every single thing.
Matt, and she didn't want to do that. She's like, come on, try to be normal, you know?
Yeah.
So we'll see. But
All
thank
right.
you for asking. You always are so kind about her.
Oh, thank you, have a good day.
You too.
All right, Mason Smith.
Judge, he's down in county court 4. We had reset for today for him to plead in county court 4, and then his case here was going to be dismissed.
Yes,
That's a DUI case. They have sent it off for retesting for drugs. So they don't have a file on the misdemeanor.
okay, so state. This is Mason Smith. There's some issue with the plea and misdemeanor court. Have you informed the state?
Yeah, I was just gonna let you know.
All right, if you want to speak to them, yes. Deputy Laura, Christopher Edwards is not. Christopher Edwards, if you come forward, please. All right, Mr. Edwards, we're going to give you a reset. Your attorneys and jury trial in another court.
Okay.
All right, Ms. Ferguson, I need a, let's do 2 weeks on Mr. Edwards. You say March 15th? We're not going to be here. All right, we're going to come back on March 9th,
Okay.
and we'll see if your attorney is still in trial. All right.
Yeah.
Varela.
All right, so Mr. Smith.
Yes, Judge, I conferred with the state and explained the situation that there's no file ready on this meeting yet. They're fine with the lease on this.
All right,
We're testing, yeah, blood on it for drugs. So
all right. How long is that usually taking?
for drugs now, Judge, I would say, I mean, a minimum of 45 days if it just got sent out.
They sent it out about 30 days ago.
Okay, so
Okay.
that should be more than 30 to 45. You know?
All right, Ms. Ferguson, Mr. Smith, if we'll recall this for 30 days and your client needs to come up here to sign the reset form.
All right.
And can you see about getting the misdemeanor set on that day as well?
Yes, I will.
All right, thank you.
Thank you.
You're welcome.
That's wrote you on.
Just one moment. Yes, counsel.
I have Mr. Jerson Rodriguez, who is in custody.
Okay. Have you conferred with the state?
Yes, I did.
All right.
They have made an offer. However.
Where's Mr. Rodriguez?
city-
Jason Rodriguez, come down, please. And counsel, he's a Spanish speaker?
Yes.
We'll need an interpreter. So just have a seat.
Por favor, siéntese, por favor.
All right, we'll get an interpreter. Is he a citizen?
No, he's not.
All right, so let's get an interpreter and he'll need does he need an immigration attorney appointed?
Yes, I think Mac has an immigration.
Oh, we're gonna take care of that. Ms. Ferguson, if we can get an interpreter here and if we can get Mac with regards to immigration. So we'll have them brought up, then I'll take your case up.
Thank you.
You're welcome. Coleman. Caleb Coleman. And counsel, I excused your client. He could appear by Zoom because I realized we're just here for the state to speak with someone.
It's the complainant's defense team.
All right.
So we were able to speak with the complainant on Friday. They did notify us where they received medical treatment, so we sent out a subpoena for the medical records on Friday.
Okay. And so where were what did the medical treatment happen?
It was a hospital insurance. So she sent us the name of the hospital and the day that she was treated, so we sent out the subpoena.
Okay. All right. Other than the medical treatment, is there any other discovery defense?
No.
Okay. And I'm sorry, when did you send that out for?
On Friday, Judge, that's when we spoke with him.
All right. So Ms. Ferguson, I'm going to want Mr. Lee recalled in 3 weeks and your client can appear by Zoom. Well, no, let's not do that. Her client doesn't have to appear because this discovery has been going on for a while. So I'm going to expect you, I know you will, keep in contact with your client and I'll let you know when he actually has to appear. But I won't have him appear for discovery because I know he has employment.
Okay, thank you.
All right. So what date? All right. So we'll be back on March 20th. And I'll make sure I write in the file that your client is excused from appearance.
Okay, thank you.
All right. Thank you.
Thank you, Judge.
You're welcome. Okay. All right. Thank you. Hello.
This is a little. You just.
Oh, thank you. You know what? See, people who are on the same wavelength. Why? Why?
I was thinking about it and then I was like, wait a minute. I'll just take care of it if you don't speak for it.
Yes.
It's like, that's the same thing.
No, no. Thank you very much. Yes. Caroline, that's what I just said. And Caroline, could you write that in the file, please? Thank you. Bashan, are you joining me on my water journey? You know what? That's the one thing we can do. I know we're going to fail the weight challenge, but I mean, let's not fail the water challenge. Yeah. Yeah, we're doing it. Me and my cup. You know, everybody always thinks there's maybe Coke in here or something else and or soda. It's like, no, it's just water. Hi.
Good morning.
Good morning. You know, you and Richard Garcia, your photos, I'm always like, where are they now? You're like, what's that movie? Waldo, where's Carmen San Diego? I'm always trying to find, I'm like, the photos are so beautiful.
Yeah, those recent ones weren't from like this weekend or next.
Okay.
Yeah.
But I just think it's so nice, you know, you have the light breeze coming across the water and the water is so blue.
Yeah.
Serenity now.
Sometimes I just want to thinking about it, you know.
Yes.
Yeah.
I will tell you, some of the most beautiful water I saw was Monaco and Greece. Yeah, I went to the French Riviera with one of my friends from law school. We said we were just going to do it. And it was just absolutely gorgeous.
Yeah, it's definitely like a magazine, right?
It is.
It's like really like that.
But now Richard has made me decide, yes, I'm going to do Egypt, but I want to do the cruise on the Nile. And I want it to be a murder mystery on the cruise. So I want it to be like a murder mystery that happens on the cruise, like Agatha Christie. But nobody gets hurt for real.
Well, it's usually part of the the sailing on it.
Well, you know, one of my mom's doctors they actually are from Cairo. So I was showing them the photos and they were like, I haven't seen what he's seen. Where is he seeing this from?
Yeah, it's Luxor is amazing. Yeah, because there's the pyramids and everything else out, but it's like Luxor, I think, is pretty impressive.
Well, I have so much on my list. So I'm just living through you and Richard, and I'll check off, this is where I need to go next.
After COVID, they're like traveling.
Yeah.
Right.
Because we're going to.
Are you?
Oh, where are you going?
Teacher.
Oh, wow. You're gonna have to make sure I see some photos.
Then afterwards, once we leave Cairo, we're gonna go to Doha. Been a few days, yeah.
Oh, I'm sorry, where?
Doha.
Oh, wow. Okay.
That's I figured since as long as we're there, might as well.
Yeah, you should.
Better Dubai too.
Yeah.
These are awesome.
Oh, now I'm adding Bali to my list because of Richard. There's so much I'm adding to my list.
And they had actually a small tremor while I was there.
Oh, wow.
Literally, like, it was in the morning,
Mhm.
bed shaking, and my mom confused, like something moved here. And we just got out in their balcony and it's just.
Well, you know, they actually had an earthquake. Deputy Laura, where was that earthquake here? And we felt it here.
Here.
No, it was in Texas and we felt it here. So my flowers were shaking and now they're cracks in part of the walls here.
Yeah.
So nobody was prepared for that. I guess we need to do a training on that. Yeah. Who's here on Brandon Sierra?
Study classes.
Oh, thank you.
Good morning.
Come forward, Mr. Sierra. All right, let me see. The last time we were here, there was a request for a jury trial, and then we were in trial on another case,
Yes.
which I remember because the videos were 13 hours. Brittany is going to say, when are you going to stop bringing up 13 hours of videos? But it's still fresh in my mind.
It will forever be in my
Yeah.
mind.
Okay. So you're still requesting a jury trial, correct?
Yes.
All right. How long are we expecting the trial to last?
Probably 3 days.
Okay. All right, Ms. Ferguson, I need a jury trial setting. It's family violence. They're telling me it's going to be 3 days, maybe.
Okay, that's fair.
I tell them I want to do it the way they do on the civil side. When you say it's 3 days, they cut you off at 3 days. They're like, no, we're not going any further.
It is set on tomorrow's lineup.
Oh, it's tomorrow's lineup. Okay, so we'll see you tomorrow. This is the thing. You're going to be brought over dressed in whatever civilian clothing you have at the jail. Counsel, if you want him to be attired in something else, then you need to do the clothing exchange, and that needs to be done today. If there's an issue, just call us and we'll see if we can help sort that out.
Right.
So
We also have a second matter, which is the only reason that he's currently incarcerated, it's only been, I think, 2 weeks, was due to the violation report.
Mhm,
And unfortunately, the 2 dates that you wanted me back, I could not be here
mhm.
for any hearings, even if if this is gonna be your decision anyway, but
Okay.
without presenting any reasons for those, for being at those designated areas.
Well, the problem, and I will tell you, and Mr. Sierra, I would have instructed your attorney this as well. I realized she wasn't here, but based upon what you charged with, and I don't take that as true because I don't know any facts of the case, but when you're on GPS, you have to follow it. And my concern was the different places you were going. It's not allowed. So we'll see you for trial tomorrow. And then if this doesn't go to trial tomorrow, if something were to occur, we'll take this issue up.
Yes, Judge.
All right, thank
Very
you.
good. Thank you, Judge.
You're welcome. And let me make sure there's a discovery acknowledgement on this case that's been filed.
Yes, sir.
Yes, it has. All right, thank you. See you tomorrow. And we have the interpreter here. Well, we have someone else who needs an immigration attorney as well. The parties on Lopez? If you come forward, where's the interpreter? Okay, all right, thank you. Hello, good morning. How are you doing today?
Very well, thank you. How are you?
Hello, it is always great seeing you.
Yes, Judge, how are you?
Oh, I'm doing great. How are you doing this morning?
Very good.
Right. And you have with you?
And I have one student interpreter with me this morning that I.
Welcome.
Thank you, Your Honor.
Okay. All right. So we're here today for a plea deadline date. But I have a few questions.
Yes, Your Honor.
All right. So is there an issue with citizenship here or no?
Yes, Your Honor, there is.
All right. Has an immigration attorney been appointed or does she need one appointed?
No, Your Honor, I am an immigration attorney.
Okay, awesome. And we'll put that down. All right, so today is your plea deadline date. So was the offer tendered? I believe it was tendered on our last setting.
Yes,
I
Your Honor.
believe so, Judge.
All right, so what is your client's decision?
Your Honor, we're going to accept the agreement
Okay,
and we're going to take the plea. We were ready to do it today, however, the file's not here and will have to be in another court.
where's the file?
I think, Judge, she was speaking with Jason. He went upstairs to go find it.
All right, so they'll get the file down for you and we'll take this up today.
For the meantime, I run to the other court and
Which court?
I have to be on the second floor with Judge Stahl.
Okay, yes, you can go there and then come back and we'll take up the plea.
Great. Thank you, Judge.
All right, thank you.
Bring the big excuse.
Well, she needs to remain, but yes, she can be excused. All right, thank you.
Judge, may I approach?
Yes. And then we have the other attorney who's here.
Yeah.
Okay. I am, Paris is my happy place.
No.
It's so, yes, I'm going to try to do that and hopefully my mom will come again. Yes,
That would be great.
it's just going to be us two ladies in Paris.
That's good.
And then even though it's a stereotype, we are going to get a beret
Oh.
and a striped shirt. We'll see what happens.
At least for one picture, right?
Yes. All right, Jerson Rodriguez. If you come forward, he's in custody.
Interpreter.
Yes, please. It's an H. Her song. Okay. And French, the H is always solid. All right. Does he only have one case, the tampering with the evidence?
He's got a.
It's a two count, Judge. It's a two count indictment.
Oh, it's a 2-count indictment. All right, so I'm trying to figure out how is this? Oh, you are with Criminal Trial Division. Since you're over here, I thought you were with Family Violence, since you're standing on this side, but you're right. All right, so where we are on this case, hasn't all discovery been received?
Well, just, yes, Your Honor, it has been received. So we do have an immigration system.
No, I understand. So I'm going to need a discovery acknowledgement done today. State, were you able to tender an offer?
We did, Your Honor.
Okay. All right, and counsel, you need a immigration attorney appointed?
Yes, Your Honor.
Ms. Ferguson? Okay. All right, we're going to get an immigration attorney appointed for you. And let me see when we're going to recall this. We're going to bring this back on March 30th. All right, we're going to have you brought back on March 30th. Before you leave here today, we'll make sure that you've spoken with an immigration attorney. That immigration attorney will come from the managed assigned counsel. If they don't have someone who's available, we'll of course have someone else appointed to represent you with the immigration matter. Now, when they talk to you about immigration, it is not globally. They're only addressing your immigration issues as it relates to whatever you choose to do on this case. Do you understand?
Yes.
Ms. Ferguson, is the immigration attorney coming down?
Can you let them know that she's making her rounds right now, so they'll get back with me in just a few minutes.
Okay, all right, so we'll have you remain in the box until you get a chance to speak with the immigration attorney, but we'll be back on March 30th. Is there anything else from either side?
No, Your Honor.
All right, thank you. Always great seeing you.
Great to see you there. Until next time.
All right, thank you. And welcome to the beautiful world of interpreting.
Thank you, Your Honor.
How many languages do you speak?
Only two right now,
Oh, only two?
the English and Spanish.
Okay, well, that's better than some. So you're doing great. All right, thank you.
Your Honor, the PAC
Mhm.
has suspended me from all further indigent appointments. So I'm allowed to handle the cases that are pending, but no more.
Okay, well, we'll have to look into that. I'm not over.
Well, I don't know who's over MAC, apparently. Gabby is the one who suspended me, so.
Okay,
I
all right, I'll see who what's to be done without that, because I have no authority over Mac. But I'll check into that.
Well, somebody must have authority over this action, but
All right, I'll look into that. All right,
been doing this for over 37 years, Your Honor.
I will look into it. You're welcome.
That be excused.
Yes. Hello.
May I approach this?
Yes.
How's this work? Am I allowed to go into the VIP?
No.
Okay.
I'm just trying to get it printed out in the back.
Mhm.
Motion early termination of
Mhm.
case. The division who handled the initial 2 years of birth is trafficking. But Stacy here to attest to what Lynn said. The clients here dress nice.
Well, I need
I'm just,
yes, you're laying the foundation.
yes, I am.
Okay.
I'm gonna get the printout from Rashawn.
Mhm.
He's prepared to take a UA, whatever the court likes. But
All
I'm
right.
just
Is he
laying it
really
down.
prepared to take a UA?
I said like 10 avions and be ready to go. when you-
Okay, we'll see what happens.
Okay.
All right.
Stacy. You took it? But this is on time. I'm the only person. No, we're just. Easy, easy peasy. Lemon squeezy.
Yeah, but
Yes,
I just wanted to grab something off
sure.
because you like obligated because I've been around for so long.
Okay. All right, thank you. I'll make sure the judges receive this as well. You're welcome. Caroline, could you email this to me, please? Thank you.
Yeah.
All right, Theda Reyes. Where's Theda Reyes? Is she in custody?
She's here, Judge.
All right, come forward. All right, so I'm sorry, just have a seat. We're waiting for Adrian Pettis. All right, well, we're waiting for Ruben. Oh, Ruben's here. Oh, then you're ready.
Judge, don't know what, I'm not sure what Adrian represents her on, but I have.
He has her on a fraudulent case, and you actually have her on a possession with intent to deliver 4,200 grams. So I believe yours may
Yes.
take precedent.
Well, Judge, I have a pre-agreement with the state. We're
Okay.
going to dismiss the fraud case and some misdemeanors.
Okay,
So I'm working on that paperwork right now.
all right, thank you so much. All right, Deputy Laura, are y'all asleep on the side? I don't know, I don't know if you want to address that with him. If you can double check because he.
Okay. So.
Unless you, if you want to, I know Adrian's out of town, unless you want to call him and see if there's an issue with you taking the plea on his behalf. I mean, that's completely up to you all. Otherwise, we'll have to recall it. Norma, see if Adrian, he's in jury trial, you say? Okay,
Judge, I would then recall the judge. So opportunity.
okay. All right. Let's recall it then. And Ms. Ferguson, see if we can, let me see the file, see if we can recall it for Thursday.
They would think that's the.
Okay, thank you.
Jamaria Simmons. Morning, Judge.
Good morning.
Sure.
All right, and Ms. Ferguson, if I could see the files back on the case involving Adrian.
Yes, Judge.
Like,
Just give me one. Oh, sure. I'm always ready. Just sign that. Okay, here we go. And just 1 second before you all leave on Simmons, though. There's still
cases on Simmons.
All right, thank you. So just give me a moment with that. And if everyone will have a seat, I'll call you as soon as I'm ready. I have to write on the docket sheet, so trust me. You're in order of appearance. And we will make it happen. All right, so Jamaria Simmons.
We're here, Judge.
All right, thank you. All right, so what's happening with, and Mr. Simmons needs to come up.
Some crutches he's approaching.
Okay. Everybody's on crutches. Is this a situation where people are no longer teenagers, but they're trying to be teenagers?
So
You had what?
I got shot in my legs.
Ah. All right, so we have a motion to revoke.
That was withdrawn, Your Honor, as I understand.
All right. And I saw that it was withdrawn on on January 30th. So there's no pending motion to revoke, correct?
That's my understanding. I didn't represent him on that. He had initially 3 attorneys, one on the NTR, one on the family division, and one on the trial division. And that trial division case is not.
All right, Ms. Abrams. All right, it's 2020 CR 2196.
That was David Woodard.
Okay. And then now we're here on the possession with intent to deliver. What is happening with this case?
Judge, we haven't conveyed an offer because the defense announced that they wanted a trial. They're intending to challenge the allegations, so.
Okay, I require an offer be tendered in every case.
Actually, an offer wasn't made.
Mhm.
We made an offer.
Okay,
At the
offer
last setting,
tender.
which was a recommendation of probation.
But I don't need to know what the offer was. So an offer has been tendered and it's been rejected?
The offer was made by Brittany, who is the family division attorney.
All right, so you want to speak with counsel and tender an offer, or are you remaining with the offer that was previously tendered?
We'll remain with the same offer, Judge. I don't think they're gonna accept anything. So
Well, I mean, people have thoughts, you know?
we'll stick with the same offer, Judge.
Okay. So, Mr. Simmons, you're aware of the offer?
Yes.
All right, so this is the way the 187 District Court works. People have plea deadline dates, and I know in some courts, people have a jury trial come in, they select jury. Maybe they thought witnesses were not going to appear, witnesses appear, and then they decide they want to accept a plea. Once the plea deadline date expires from this court, the court will only consider plea bargaining agreements with good cause. And good cause is not, I didn't expect us to actually go to trial. Good cause is not, oh, witnesses are appearing. That's not good cause in the eyes of the court. Otherwise, if you decide to plea, you have to plea open to the court. Do you understand? All right. Have you received all the discovery?
Have a discovery acknowledgement.
Mhm.
Acknowledges that I received what they have.
All right, I don't have a discovery acknowledgement in this file. And I think maybe it's because this is a temporary file. The file was lost or something. So,
We filed it several years back.
all right, so state, if I can get a discovery acknowledgement for this file.
Sure, Judge.
And how long is this trial going to take?
2 or 3 days.
Okay.
There's a few more witnesses than a normal drug case.
All right. All right, Ms. Ferguson, I need a jury trial date for Mr. Simmons, please. All right, your jury trial date is April 3rd. Your plea deadline date has expired. Counsel, you and your client are I'm sorry, with regards to withdrawn?
That's been filed and done already.
Okay. All right, thank you. All right, we'll see you on April 3rd for your jury trial. Thanks for dressing appropriately for court, even though you're on crutches because you've been shot.
Thanks.
You're welcome.
We excuse Judge.
After you sign the reset form and sign the acknowledgement of discovery. Pedro Sanchez. Pedro Sanchez, who's the attorney?
He's got it pending case in 11, so I think Mark was out there.
All right, so just give us a moment. Gregory De La Cruz. And Mr. De La Cruz, where are you? Come forward, do not be shy. All right, so this is a motion for early dismissal. We're going to go on the record. Court is calling 2020 CR 6871, State of Texas versus Gregory De La Cruz. Can I have parties announced for the record for the state?
Stacy Harrington.
Defense?
Tom Nisbet for the defendant.
Are you Mr. De La Cruz?
Yes.
All right, the defense has filed a motion requesting early termination. The court has reviewed documents where motion for early termination was presented to the court previously, and the court denied it. And that was on, let me see, April 30th, 2022. State, have you had a chance to review the defense's request?
Yes, Judge.
Do you have any objections to it?
No, Judge. We have spoken previously. I have also had the opportunity to show those documents to Mr. Lunan, who handled this case, handled the plea, and worked with the previous defense counsel. And Mr. Lunan himself said that if asked by the court, that he would not stand in the way of the defense request for early termination.
So the state is in agreement with the early termination?
We are not opposed, Judge. We do not object.
So the state is in agreement?
In so many words, yes.
So yes, the state is in agreement? All right. Probation?
In agreement.
All right, Mr. De La Cruz, if you drug tested today, what will the results be?
I'll pass.
All right, well, let's see if he's going to pass. Do you need any water?
Please.
All right, so Mr. Nesbitt, if you make sure he gets water.
Yes, ma'am.
Now, we're out the record. Now, Mr. Nesbitt is a little bit
No, I'm
shaky.
good.
You're okay?
I'm not, I just recall that the court has a certain opinion of people who do or don't ask for waters.
But I think for the record, well, not for the record, but I think your client is going to be fine, but I still want to know.
I'm gonna get it done.
All right, thank you.
Judge, do you need anything further from the?
No, you can be
Okay,
excused.
thank you, Judge.
Judge, on Mr. Simmons, our discovery acknowledgement is filed.
Yes, and I've signed that. And you received your reset form?
Yes.
All right, thank you. All right, are we back on Pedro Sanchez? Not yet? Okay. Judge Contreras, it's always good to see you.
It's always great to be here, Judge.
I see you here and I see you here.
I'm not here, you can always.
Yeah.
It was.
Okay. Oh, and the San Antonio bar gave me the photos from that day. So I'm going to be sending those out. I just received them, so I'll send them out so you'll have them. You're welcome.
I'm not here wasting my time.
You better get her. I mean, we got pretty good. That's why I thought I would. Oh.
I don't know. They never- they never look out the record. I don't even want to come down there. I don't care.
That's exactly.
Close to shooting fire.
No, it was fine.
Well, if you had a call, email, that's the offer, then I'll bet you will try to call. First time.
Oh, yeah. Well, maybe not. Where's he at?
Oh. Other Chinese.
Must have been. My understanding.
It is 17.
No, I just.
As I said. Excellent. Sage on the pictures. He said. Yeah. Looks nice. Yeah. Everybody else. Didn't bring his phone because he knows he's been locked up. His family said. I have the person. Oh, no, I read this.
Oh, yeah.
This one, this one type of things, that's just so okay. So she's a guy. I'm gonna go downstairs for a few minutes. And then I'm gonna go back. If you want to bring them in, okay? Hi, Judge.
Hello.
Yeah.
Okay, you're going to move over to the other places.
All right, just give me 2 minutes. I'll come back. Isn't that cool?
So if I was.
I'll be right back.
That's not even. Years I'll be doing. Okay, I'll tell you what they want to see. Yeah. Never got seen. They have to contact.
Me? Yes, I was looking for you. Did you can stuff like that with me? No problem.
Just my approach.
Just a moment.
Oh, so.
But anyway, so. Okay.
All right, who are you approaching on council?
Defendant John Meyer. And he might be on. Judge.
Okay, I'm going to get to you because I go in order of appearance. So Pedro Sanchez, is the attorney here for Pedro Sanchez? All right, just give me that back when they're ready. John Meyer. Yes, come forward, Mr. Meyer. All right, what's happening in this case?
I just wanted to request to be said, the state is missing the affidavit for the arrest warrant. In their file on any discovery, and they're going to try to track it down from the sheriff's for me.
All right, are all these cases on the same day?
They're two separate days, Judge.
All right, so what's happened? Which case is the one with the affidavit?
The newer cases. You have the discovery on the first case.
Okay. All right, and state, how long is that going to take?
Yeah, a couple of weeks. I'm working on the email right now, Your Honor.
All right, so Ms. Ferguson, on Mr. Meyer, I'm going to need a 30-day reset. All right, so we're going to come back on March 20th. At that time, state, I'll expect an acknowledgement of discovery and an offer to be tendered.
Did you say 20-day reset or 30-day reset?
Oh, it's March 20th.
That sounds like 20-day reset.
I know. You know, sometimes Ms. Ferguson gives us a longer reset date than I asked for, and sometimes a shorter. I never complain about the shorter days. He's fine with the 20th.
Can we do the 27th? So that's like.
Okay. All right. Thanks for dressing appropriately for court. You're excused as soon as you get your reset form. And what date, Ms. Ferguson? Okay. Pedro Sanchez. All right, where's the attorney? Why do I keep getting this phone? We're still waiting for your attorney.
Your Honor, I could speak a little bit. I believe he's going to deal with the case in 11, and it should.
All right, and when is the setting date going to take place in 11?
I'm not sure. Not sure.
All right, we'll wait for your attorney. Oh, this one's done. And are we ready yet on Gregory De La Cruz? Yes. Okay, well, we'll call the case. Okay. All right, thank you. All right, Adrian, Arias. Can you come down, please? Good morning, Mr. Arias. How you doing? Oh, I'm doing great. I mean, it's Monday. It's always time for new beginnings. All right, so my understanding is you all are going forward with this motion to revoke. You're going to enter a plea of not true or true, and then the court is going to make a decision because there's no agreement. Is that correct? All right, so what I'm going to need you to do, counsel, if you can get a trial court certification of defendant's rights to appeal.
I gave it to the lady.
Oh, okay. All right. Let me see. Where is it? All right. So trial courts, Mr. Arias, on a trial court certification of defendant's rights to appeal, your signature on it is acknowledging that you understand that based upon what I do on this case, maybe you'll have a right to appeal, maybe you won't have a right to appeal. You understand? All right. So I'm going to need you to sign right here at the bottom where it says defendant. Counsel, there you go.
Why don't you just tell me that I wouldn't have the right to appeal?
Now, I'll make a decision on that once I hear everything. I can't tell you if you have a right to appeal or not until I hear everything. Thank you. Thank you, Mr. Arias. All right, we're going to go on the record. So I'm going to need everyone to make sure you whisper. And if you're in the box, please do not talk behind the court reporter because that makes her job more difficult. And it is a Monday and we're trying to make people enjoy their professions today. All right, court is calling 2020 CR 12347, State of Texas versus Adrian Arias. Could I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
Ted Wood for Mr. Arias.
Are you Mr. Arias?
Yes, ma'am.
All right, Mr. Arias, I'm going to show you a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
We can review it, but I did read it.
All right, do you want to have a chance to review that with your attorney? Are you sure? Because we're here. All right. Are you the same Adrian Arias who was placed on deferred adjudication in 2020 CR 12347 for the offense of deadly conduct firearm on May 9th, 2022 for a period of 4 years? Is that you? All right, state.
Your Honor, in violation of condition number 2, on or about the 22nd day of July 2022 in Bexar County, Texas, the defendant, Adrian Arias, did then and there fail to submit to drug testing as instructed by the supervision officer in violation of condition number 2.
Just one moment. There has to be another motion because I only have the one that has a violation of condition number 25. Probation, do you have a copy of the other motion? I don't have it.
This might be an old one, actually, that I have.
I got it from probation. Stand.
Because the only one I have is dated, that was signed on February 3rd. And that's a violation of the substance abuse treatment facility.
That's probably the correct one.
No,
It's an old one.
so I believe it's this one.
It is the old one. Oh.
Yes, so this one has previously been heard. So are you withdrawing the entry of violation of condition number 2, state?
Yes, Your Honor.
All right, you may proceed.
Okay. Violation of condition number 25, on or about the 3rd day of February 2023 in Bexar County, Texas, the defendant, Adrian Arias, did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department Substance Abuse Treatment Facility, and that the defendant has been unsuccessfully discharged from the Substance Abuse Treatment Facility program in violation of condition number 25.
How do you plead to that? True or not true? All right, can you state? Did you understand by pleading true to violation of 25, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to $10,000 fine? Were you aware of that?
Yeah.
No, I mean, not you believe so. All right, so this is what I want you to do for me. Straighten your body, look me in the eye, all right? So were you aware that by pleading true to violation of condition number 25, the court could find it true, find you guilty, and sentence you up to 10 years in prison and up to $10,000 fine? Were you aware of that?
I wasn't aware it was up to 10 years, Your Honor, but you did say. I thought you could tell me.
All right, so you're gonna have to stop mumbling. You're gonna have to open up so I can hear you.
Yes, Your Honor.
All right, knowing that, do you still wish to plead true to violation of 25? All right, the court is finding violation of 25 true. Is there an agreement?
Your Honor, there's not an agreement.
State, what are you requesting?
Your Honor, we would request, he has shown, probation has not been successful for him. The treatment facility, he could not abide by the rules. There were other significant allegations that came out of that, Your Honor. So our recommendation would either be to revoke, to make an adjudication of guilt and revoke, or if the court is inclined to continue him for safety.
All right, defense, what are you requesting?
Judge, Mr. Arias and I talked extensively last week about what happened in SADF. It's unfortunate. What I'm asking for, Judge, is that you deny the motion to enter adjudication, send him home to let him wait on a treatment slot at felony drug court. I believe he's been accepted into felony drug court. I think that SADF may have been at terms and conditions of his admission into felony drug court. He's excited about getting into felony drug court.
Well, I mean, is felony drug court going to accept him because he was unsuccessfully discharged from SADF?
Maybe not, Judge.
All right.
That may be an analysis that, I can reach out to Deanna or CJ or somebody and see if what they have to say about it. We can reset this for another day if the court please.
No, we're not gonna reset it for another day.
Spoke to them, Your Honor, and they told me that I qualified for drug court
When was this talking to them?
about 2 weeks ago.
Who requested that he be referred to felony drug court for them to have spoken to him 2 weeks ago?
Your Honor.
All right, and did you get an update?
The report that I have, it means meets the criteria, however, he was rejected. Felony drug court with the asking. And so their recommendation was to refer him to safety because of the act. That was done, that report was sent on February.
All right. All right, so here's the thing, Mr. Arias. It appears to me that you don't want to be on probation. It appears to me that you wish to continue with your drug use. And there are some things that I can help people with and some things that I cannot. For example, I can give you all the tools possible. I can fill up your toolbox with this is what you do if you have the urge to use. Here's a treatment program we can give to you. But if you want to accept it, and if you're just living your life the way you want to live it, and then coming to the court asking for mercy, that's not going to fly.
Oh, no, that's not true, Your Honor. I've never been MTR'd out of any probation. I've always completed them, Your Honor. My probation officer treated me unfairly, Your Honor, revoked me for all kinds of things. I was 2 months into a 4-year probation period, and she revoked me for every last stipulation there was on it, Your Honor. I was trying to.
Well, here's the thing. Time out. Here's the thing. You can say, maybe, I don't know. I don't like people to speak ill of people who are not present. You can say that maybe your probation officer, maybe y'all have a personality conflict, a communication conflict, and you all don't get along. But the fact that they're putting violations in your motion to revoke, you can't say it's not true. If it isn't true, then we'll go there. You can't say that you're not using meth or marijuana. I mean, maybe you want to say that, but when probation officers put allegations in these motions, sometimes maybe they'll let other people slide. Maybe the person who doesn't report exactly at 9 a.m. on the 12th when they ask them to, maybe they come on the 13th, they let them slide. And then maybe for you, they don't let you slide. But the rules are in place and there are consequences to every rule. Do you understand? And I don't know why people seem to think that there should not be any consequences for actions, but they are. Like, here's the thing. If I don't pay my electric bill, you know what the consequences of that are? Coming home to a dark house. I don't pay my water bill. You know what the consequences of not having water? Knocking on my next door neighbor's door. And my neighbors are great. I know if I knock on their door, they'll let me spend the night there. And I'll say, please don't tell my mom I didn't pay my bill. But you have got to make a decision on what you want your life to be. If you want your life to be constantly looking over your shoulder because you're not doing what you're supposed to be doing, constantly worrying about when you're going to get your next drug so that you can live a life of being high, that's on you.
Your Honor, I had quit using drugs, Your Honor, and I told her that. When I took my second UA, I told her I was gonna UA dirty, but that my level should be lower, and on the third UA, I would be clean.
Why are you not doing safe? Why was there an issue with SATA?
Because I had been single out, Your Honor, by the younger men there, and they had been pushing me, and eventually just became too much, Your Honor. And I got into a fight with one of them. There was a day one of them threw a roll of toilet paper at my face. I was watching TV. Here comes a roll of toilet paper. It's the one next to me. I did nothing about it, Your Honor. I looked at them. I kept watching TV, Your Honor. I tried, Your Honor. They pushed me and pushed me.
Probation?
They wouldn't leave me alone.
Could I see the documentation on this being released from SATA?
I was doing everything else supposed to do, Your Honor.
All right, so people, when we're on the record and you're behind the court reporter, please do not talk. Or either just ask the deputy if you can move your client to the other end, because probation cannot hear. Right, thank you. Okay. All right, so this is what I'm reading. I need everyone to please whisper. It says on February 3rd, 2023, security monitor was monitoring the central dorm as he was preparing the residents for recreation and getting up from his desk. Mr. Simmons witnessed both residents, Arias and Bruno, fighting without warning. Shift leader and Castro, along with other staff members, responded quickly. Resident Bruno stepped away with a bloody nose and resident Arias with a bruise in his face. Both residents received medical attention. Minutes later, this RCSO watched the video surveillance and saw resident Arias aggressively headbutt, throw a punch, striking him in the face, and then place resident Bruno in a chokehold. This RCSO spoke to resident Arias about his involvement in the fight, and resident Arias admitted the fight between him and resident Bruno occurred in the central dorm. Resident Arias said that the resident Bruno asked his age and made fun of him. Resident Arias stated he told resident Bruno to go and get in shape because his nipples looked like a 12-year-old girl. On February 3rd, resident Arias was returned to Bexar County. So it appears that your behavior is not good behavior.
Okay. And I told them how it happened, and they said to me, that's what it looked like.
Right.
I never punched that guy in the face, Ronnie. Yes, I did headbutt him, Your Honor. I didn't punch him in the face and I didn't put him in a chokehold. When I headbutted him, he grabbed my leg. He tried to take me down to the floor, Your Honor. He ended up pushing me back a couple of bumps. Yes, I grabbed him in a headlock because he was holding on to my leg, Your Honor. I never punched him in the face and he never stepped away. They pulled him off me.
All right, you have a choice today. Here's your choice. I will send you to prison for 4 years, or you can go to safety. Those are your two choices. There is no third option on the table. What would you prefer? All right, the court will deny the motion. Alter and amend conditions to include safety. And upon release, there's to be 90 sober meetings in 90 days. And probation, you can see if felony drug court will accept him. Is there anything else?
No, Your Honor.
All right, anything else, Mr. Arias? You're welcome. You had better start doing, we're off the record. You had better start doing better, because the other thing that was in that report is that you are minimizing your drug issues. And let me just tell you, anybody who's putting illegal substances in their body and sometimes prescribed substances in their body need to acknowledge that. And if you can't acknowledge that you have a problem, nobody can help you with the problem because you don't even see it as one. Do you understand? Do you really want to say something? I think you probably don't want to. Okay, let's hear it.
I started using methamphetamine because I had.
Because what?
Because I had priapism.
Mhm.
Okay. And I went to the hospital and they almost killed me. And it left me traumatized, Your Honor, and they wanted $40,000 for surgery and I didn't have $40,000. They don't have medication for pilot. And the only thing I could come up with to help myself was.
All right, so here's the
they didn't
thing.
help me, Your Honor.
Now, here's the thing. What you're doing now is you're making an excuse for your use of meth.
I'm done, Judge.
Yeah.
I'm
Well, we will see.
47 years. I'm pushing this. I got to do it.
Well, you need to let them know it's safe, Pete, and you need to follow through. If you don't, you're going to find yourself back here. And from here on out, you need to realize you're looking at up to 10 years in prison. Do you understand? All right, good luck to you.
Thank you.
Are you ready on Gregory De La Cruz?
Yes, good.
All right. Do we have the result? Oh, that is awesome. All right, Mr. Cruz, I'll grant your motion based upon the state's requests and probation's input. All right, is there anything else?
No, Judge, may we be excused?
Yes.
Thank you.
You're welcome. Who's here on JC Laday? Hello, how are you doing?
Good.
And how do you pronounce your last name?
Mine?
Your clients?
Laday.
Laday? All right, so there are no extra syllables, okay. Court is calling 2022 CR 11874, State of Texas versus JC Laday. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
Well, no way for the defense.
Are you Mr. Laday?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Laday, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
ma'am.
Counsel, do you waive the reading of the indictment?
You, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, the state will waive the enhancements and proceed on the ag assault deadly weapons second degree.
No objection, since.
All right, Mr. Laday, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
No.
Counsel, did you understand what you're charged with is aggravated assault with a deadly weapon?
Yes, ma'am. Yes, ma'am.
Uh,
Wait a second. Oh,
Yes. The range of punishment for that offense is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Laday, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial.
Yes, ma'am.
Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. There's an affirmative finding of deadly weapon, no applications, and an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of your plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
We have for states exhibit number 1 on attachment.
Any objection?
No objections. For purposes of
All
the
right,
plea.
state you may be excused to continue to confer. Mr. Laday, not you.
Sorry.
Mr. Laday, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just that you follow the plea bargain agreement. Your Honor.
All right. Court will sentence you to 2 years in the prison. Give you credit for any time served. There's an affirmative finding of a deadly weapon. And there's an affirmative finding of family violence. Is there anything else from either side with regards to sentencing?
Nothing further from the defense.
All right. And I'm sorry, let me see. I am going to do a no contact order. And I know that wasn't requested.
Your Honor,
Your Honor,
the witness is deceased.
No, there are other people
yeah,
in the
with-
household.
with the roommate, yes.
Yes. So is there going to be any objection to the court adding to the plea that he's to have no contact with Angel Vasquez, Sarah Espinoza?
Can I quick moment?
Yes. And Nathaniel Zermino.
No objections.
All right. So the court is going to order also no contact with the following persons: Nathaniel Zermino, Zermeno, Sarah, Sara, Tiffany with an I, Espinoza with a Z, and Angel Vasquez. All right, Mr. Laday, showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is an affirmative finding of family violence, and also because this is a conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
23.
All right, you're 23 years old. You're going to have to start changing your life. If there's a drug or alcohol problem going on with you, you need to make sure that you take care of that, because otherwise you're going to be in and out of prison and in and out of court system. You understand?
Yes, ma'am.
All right, good luck to you. Thank you, counsel. Who's here on John Marino? John Marino. We'll wait for your attorney. Who's here on Jonathan Temes? All right, if you'll come forward with your client. Probation, this is a application for deferred. All right, the court is calling 2023 CR 0467, State of Texas versus Jonathan Thomas. That parties announced for the record for the state.
Jason Jorgens for the state.
And Andrew Fraley from Mr. Thomas.
All right, and are you Mr. Thomas?
Yes, Your Honor.
Counsel, you received all the discovery?
Yes, Your Honor.
Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Thomas, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving count 2 and proceeding on count 1.
Any objection?
Okay.
Mr. Thomas, I'm showing you what's entitled court admonishments. Did you review that with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with theft of a vehicle as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, I'm sorry, Mr. Thomas, did you understand if the court would have granted your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Just one moment. There are a lot of doctor's appointments going on today, so just give me a moment. All right, we're back on the record. Mr. Thomas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, state is proceeding on count 1. There's an $800 fine. State recommends deferred adjudication. And there's restitution, if any, to Julia Morales. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your deferred adjudication be for a term of 2 years. There'll be a TAP evaluation, 120 hours community service restitution, no contact with Julia Morales in cats 1 and 2. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged in count 1, how do you plead? Guilty, not guilty, or no contest?
No contact.
State any evidence?
Yes, Your Honor. The state offers exhibit 1, the defendant's waivers and stipulation of evidence.
Any- All right, state, you can be excused to continue. All right, Mr. Chumez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
All right. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept it to evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, sir.
Anything you wish to say on behalf of your client? How old are you?
23.
How far did you go in school?
To 9th grade.
Why?
I dropped out.
Why?
Why?
Yes.
I wasn't doing good at school.
So what are your plans?
Getting a job.
How are you going to get a job with a 9th grade education? I'm sure there's some things to do, but
When I have a high school diploma, I did a homeschool program.
all right, so you have your GED.
Yes, ma'am.
When did you get your GED?
From next day leadership, San Antonio leadership.
When?
When? Back in 2016.
All right, so you have that in 2016 and you committing this offense in 2022. So why does it take coming to court for you to decide that you're going to get a job and live your life right?
Judge, if I can, I had a discussion with my client earlier today, and after he's now placed on probation without a felony conviction, we hope that he's going to get a job. There's a job lined up. Is that correct? You tell the judge where that job is that you have lined up.
That's at Ashley's friendship.
Everyone, please whisper.
Ashley's friendship.
So you can now go and get them. You have a friend who's recommending you and you have that all lined up.
Yes.
Okay.
All right, so why are you taking this vehicle that doesn't belong to you?
I was under the influence.
Of what?
Of Xanax.
I mean, you must be have been under the influence to steal someone's vehicle and then take it to the car wash. So when you're drug tested today, what are the results going to be? And before you tell me, I want you to know, you're going to get drug tested today. So you need to be honest with me.
Wait for her to finish the request. We discussed this already.
Okay.
He's prepared.
So what do you, if you're drug tested today, what are the results going to be?
Meth and weed.
So where's the Xanax? So you're going to be positive for meth and weed. How often are you using meth?
Probably like everything.
Every day. No one is going to want you moving heavy furniture and going to their homes when you do meth every day. And the fact that you took someone's car, I don't know if Ashley's Furniture is going to hire you because they don't want the responsibility of having someone working for them who's going into somebody's home, moving furniture. So you're probably going to have to find a different job. Do you have any children?
Yes, ma'am.
How many?
1,
Age?
2,
And where is your child?
with my wife or with my girlfriend.
Hold on. So we- may I-
Yes.
We discussed this answer as well. Y'all are still together.
Yes.
And you're supporting the child
Yes.
financially and emotionally.
Yes.
All right, you can't support a child financially if you don't have a job. How are you supporting your child financially?
I'm working with my brother's father-in-law. We do AC.
All right, and the mother of your child, is she using drugs as well? Let me just tell you why I find that a little bit hard to believe. It may be true. It's a possibility. It could be true. But usually people who are using drugs hang out with other people who are using drugs. Now, I will go up and support people who are running marathons. If my friend is running and they're like, Stephanie, come support me run a marathon, but I'm not having meals with them because I don't do marathon running. If you hang around a barbershop often enough, you're going to get a haircut. So here's my question for you. Do you have some other place to stay? Because I cannot have, does she work?
Yes, ma'am.
All right. And so that means that while she's at work and your child is too, that means that your child is not.
Well, she's not working right now. She's pregnant at the moment. So she's ready to stop working.
Yeah, well, you can't live with her.
I know.
What's her name?
Hannah Yanes.
I'm sorry, what?
Hannah Yanes.
Hannah Yanes. So is there another place for you to stay?
I've been staying with my brother.
All right, so you're not allowed to live with her, you understand? All right. This is what, yes.
Sorry, my client's nervous. I was just letting him know, just like, wait, Richard, you finishes, then you can talk. He's trying his best.
All right, so this is what we're gonna do. 3 years deferred adjudication. $800 fine, that will be probated. Probation, I'm gonna want a TAP evaluation. A referral to felony drug court. And you need to be 100% honest with felony drug court and they will probably accept you.
Yes, ma'am.
I'm going to run a referral to felony drug court and do that first before the TAP evaluation or do it in conjunction with the TAP evaluation. If felony drug court does not accept him, I'm going to want intensive outpatient treatment with probation. I'm going to want 90 sober meetings in 90 days. There's to be no unsupervised contact with minors. He is not to reside with Hannah Yanes. Proof of employment within 30 days. No employment as a home health care provider or with minors. Restitution and no contact with Julia Morales. Cats 1 and 2. Cats 1 and 2 is something that everybody should learn. So I'm going to give it to you. Here's Cats 1 and 2. Don't take what doesn't belong to you. And as a side note, which is not including cats, if somebody invites one of your friends to a party, if they have not been given to have a +1, don't go. If you end up going to somebody's house and they ask you to leave, leave. That's Cats 1 and 2. All right. 120 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you the COVID vaccination, but if you do, 40 of those hours be waived. I'm going to want parenting classes with triple P. The remaining of the hours will be waived once he completes that. There's to be regular reporting by Zoom or in person. I'm going to want field visits 2 times per month until further notice. And probation, make sure they check on the children to make sure that he's not unsupervised around the children. And we're going to do the UA hotline until further notice. Probation, is there anything else he needs? Yes.
Did you mandate tasks 1 and 2?
Yes.
Nothing else.
All right. Is there anything else you need from the court to be successful? Showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. Here's the thing. You're 22. You're bringing children into this, 23. You're bringing children into this world. And they're 100% dependent upon you. No child, when they're, coming down saying, hey, I want the person who is using drugs on a daily basis and stealing cars to be my father. You still have a chance for your children to maybe be proud of you. So you're going to have to stop using drugs, get a job, and be a parent. Being a parent is more than just producing offspring. They need financial help, they need love, they need support, and they need someone to show them the right way to do things. So you're off to a bad start and you're going to correct that. You understand? All right, good luck to you. Tanya, Lopez, Methu. Hello, good morning. It's always great to see you. I love when interpreters come down. I get to practice my language in the head. All right. Court is calling 2023 CR 0550 and counsel, you need to be on this side. State of Texas versus Tanya, Jacqueline, Lopez, Methu. Can I have the parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Brown for the defendant.
And are you Miss Methu?
Yes.
Am I pronouncing your last name correctly? Matthew. All right. Never be afraid to tell someone they're pronouncing your name incorrectly. That's the only way I learn. All right, we have an interpreter here. If you could raise your right hand for me, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English? So help you God.
I do, Your Honor.
All right, could you state your name for the record, please? All right, thank you. Counsel, have you received all the discovery in this case and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Counsel, are you able to speak Spanish?
Yes, Your Honor.
And do you speak it fluently?
Yes, Your Honor.
And were you able to communicate with your client in Spanish?
Yes, Your Honor.
And were you able to go over the entirety of the documents with your client in Spanish?
Yes, Your Honor.
Ms. Methu, all of these documents are in English. Were you able to review those documents with your attorney in Spanish?
Yes.
And do you have any questions about any of the documents that you've signed?
No.
Right. Did you review the application for community supervision with your attorney? Did you understand it and did you sign it?
Yes.
Did you review the document entitled True Bill of Indictment with your attorney and did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, we're proceeding on paragraph A and waiving paragraph B.
Any objection?
No objection, Your Honor.
All right, Miss Methu, did you review the document entitled Court Admonishments with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with driving while intoxicated with a child under the age of 15 as a state jail felony?
Yes.
The range of punishment for that offense is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you are giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Methu, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Okay. Are you a U.S. citizen?
No.
All right, counsel, did you advise the defendant of the consequences of pleading no contest or guilty in the application of federal immigration law?
I have, Your Honor.
Did that advice include possible consequences such as deportation, exclusion from admission to the United States, or the denial of naturalization?
Yes, Your Honor.
Do you believe your client understands the consequences of entering a plea as it relates to her immigration status?
Yes, Your Honor.
Ms. Methu, were you advised of the consequences of pleading no contest or guilty in the application of federal immigration law?
Yes.
Did the possible consequences such as deportation, exclusion from admission to the United States, or the denial of naturalization, were those consequences explained to you by your attorney?
Yes.
And do you understand the consequences of entering into this plea as it relates to your immigration status?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, prosecution is proceeding on paragraph A. There is 11 months in the state jail facility, a $1,200 fine, no application for deferred adjudication, and the state is recommending community supervision. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Outside the plea bargain agreement, the state is asking for your community supervision to be for a term of 2 years. There be a TAP evaluation, 120 hours community service restitution, DWI education, DWI victim impact panel, ignition interlock for half the term, 2 years driver's license suspension, parenting courses, and regular UAs. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offense as charged in paragraph A, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the plea?
State all which states to the one and all attachments.
Any objections?
No objection.
All right, state, you may continue to confirm. All right, Ms. Methu, did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. My client was brought into this country from Honduras at the age of 15, left to be alone to defend herself. She's now 23 years old. She has 2 United States children. She has managed to get this far up until this incident. She's very aware of the consequences because of this incident, and she understands we'll never do this again.
All right, Ms. Methu, you understand while you're on probation, you're not allowed to drink alcohol at all?
Yes.
All right, are you employed?
Yes.
What do you do?
I'm a waitress.
All right, where are you a waitress?
El Taco Loco.
All right, do I know El Taco Loco? What is served there?
Mexican food.
All right, so if I were to go there, what should I order? And it's a safe bet. Okay, she didn't even need the interpreter. She's like bean and cheese. All right. I only recently discovered bean and cheese. That is a great combination. All right, so I'm going to sentence you to 11 months in a state jail facility, suspended and probated for 2 years, proof of employment within 30 days, no employment as a home health care provider with minors, 120 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. Parenting classes. Once that's completed, the remaining of the hours will be waived. DWI education course. DWI victim impact panel. Ignition interlock half term. 2 years driver's license suspension. Regular UAs. Regular reporting by Zoom or in person. We'll do field visits 1 time per month for 2 months, and probation, if all is going well with the field visits and you all think it should be discontinued, then it can be discontinued. If there are any issues, let the court know. Probation, is there anything else she needs? Ms. Methu, is there anything else you need from the court in order to be successful?
No,
Right.
thank you.
Did you review trial court certification with your attorney? Did you understand it and did you sign it?
Yes,
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
yes.
All right, good luck to you. All right, we can go off the record. Your attorney is telling me that you've been doing good things since this incident. So you're gonna have to make sure that everything that you do from here on out, you think about your children, okay? All right, thank you, thank you.
Thank you, Judge.
All right, Ms. Compton, who do you have? Oh, thank you. Yes, you may. Always great seeing you.
My pleasure.
All right. All right, who do you have?
Bernardo.
All right, Bernardo Huerta. Michelle, did you need me? Did you need me for something? Okay. All right, today is the plea deadline date. Mr. Huerta, today is your plea deadline date.
Judge, we've discussed the plea bargain offer previously, and my client is choosing to decline that and to decline making any counter offers to the state.
All right, your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. You understand?
Yes, ma'am.
All right. All right, state, how long is this jury trial going to last?
Judge, that's probably 2 to 3 days.
All right. Ms. Ferguson, I need a jury trial date. This is criminal trial division, 2 to 3 days. All right, we're going to come back on April 3rd for your jury trial date. Counsel?
Judge, I just, out of an abundance of caution, I believe I have a vacation letter if that's the week of Good Friday, and just don't want to run up on.
Oh, no, I understand.
I may have put in, I think, that Thursday before. I know I'm gone the Thursday, Friday, and the following Monday.
Okay. Ms. Ferguson, we need a different date for her other than April. Well, so you're gone the week of April 3rd?
I would have to double check, but I think it's the Thursday before Good Friday, and then the following Monday.
All right, because we won't be, I'm releasing everybody for Good Friday because we're not going to have court on Good
The
Friday.
Thursday before. So I just, I always think it's great when we say 2 or 3 days, but then of course, usually that would be when something weird will happen and I'll be like, oh my gosh, remember I said I had to.
All right, Ms. Ferguson, how about the week of April 17th? Well, what is it? Well, the week of April 3rd, the 3rd, you're putting that. So that's criminal trial division. And then the week of April 10th would be family violence. And then the 17th would be back to criminal trial division. Am I reading the calendar wrong? Yes.
Oh, I thought, okay, that's fine.
Is that criminal trial division or no?
Yes, it is.
All right, so April 17th.
Thank you, Judge.
All right, thank you. Mr. Huerta, you're going to be brought over dressed in whatever civilian clothing you have at the jail. If you want to be dressed in something else, you'll have to do a clothing exchange with your attorney.
I discussed that with him. Thank you, Judge.
You're welcome. Hello. Sure. Okay. You're welcome. Who's here on Ronnie Simmons? And is it very hot in here? Or is it just me? Yeah. And you know what? See, it's warm here. And if building maintenance would walk, they'd know it's warm here. And then in other courts, it's freezing. But they say it's all our imagination. And Deputy. Okay.
I know I just watched the plea. Are we sitting in the right locations?
Oh, you're on this side. All right, and this is for deferred adjudication.
Correct. Judge.
Court is calling 2023 CR 0791 State of Texas versus Ronnie Simmons. May I have parties announced for the record for the state?
Ruben Herrera for the state.
John Pitts
Defense.
for defense?
And are you Mr. Ronnie Simmons?
Yes.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Simmons, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yeah, Your Honor.
Mr. Simmons, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand what you're charged with is assault, family, second offense? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? You need to speak up.
Yeah.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Sure.
Did you intend to give up those rights and enter into a plea in this case? Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Simmons, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that case? I'm sorry, did you review that page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, the state is recommending deferred adjudication. They are taking in consideration 2023 CR 0790. And are you aware if the court finds that this was an affirmative finding? I'm sorry, are you aware that the court could find that this was an affirmative finding of family violence case?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand?
Yes.
All right, you all want to put the affirmative finding?
Problem.
Oh, no problem. And if you all could initial that, please. And Mr. Simmons, did you understand that to be the entirety of your plea bargain agreement?
Yes.
Defense, is that the plea bargain agreement?
Yes, Judge.
State, is that the plea bargain agreement?
It is.
All right, everyone, just give me 2 minutes. Nobody move from this spot. I just have to check on an appointment.
All right.
All right, thank you, everyone. Please be seated. And everyone, thank you for your patience. When you're dealing with doctor's appointments for other people, it gets a little dicey. All right, we are back on the record. All right. Showing you paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Do you understand?
Yes.
Counsel, are there any such motions?
No good.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your deferred adjudication be for a term of 5 years. There'll be a TAP evaluation, no contact with Cheryl Simmons, no harmful or injurious contact with Ronald Simmons, and of course, there's an affirmative finding of family violence. I know that y'all have put affirmative finding of family violence below the line, but if there is if I deem that this is a family violence case, there will be an affirmative finding of family violence. Does everyone understand?
Yes.
All right, other than that, did everyone understand that I don't have to follow the recommendations from the state? Did you understand?
Yes.
All right, then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Okay.
State any evidence?
State offer 6 exhibit 1 and all attachments, Your Honor.
No objections, Judge.
Show you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, but most importantly, there'll be no live testimony? Did you understand?
Yes.
All right, the state, you can be excused to continue to confer. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, I review in states exhibits 1 and attachments. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Judge.
All right, so first question I have, Ronald Simmons. Is Ronald Simmons married to your mom and do they live together or no?
Father, actually, Judge. And I think. Yes.
So they live together. How old are you?
32.
You're 32 years old. And is this complaint in this case your biological mother?
Yes.
Why are you hitting your mom? I mean, don't do this thing where we're shaking our head, we're trying to consider, because what I just read is you punch your mom in the mouth. We only get one mother. And it says that she was bleeding. I mean, if you want a jury trial, well, I'm here. Anybody who wants a jury trial is more than welcome to have it. But it appears that you have some anger issues because this is a family violence second. This is not a first. How old is your mother?
46.
When's her birthday?
May 30.
You sound very unsure. All right. So why are you hitting on your mom? All right. And at your age, even if you were younger, if your parent doesn't want to drive you somewhere, they don't have to. That's what via buses are for. That's what getting a job and getting your own car for. When this happened, were you living at that home?
No.
So you're coming over starting problem. And this previous assault family violence case, who was the complainant in that case? On March 25th, 2022, you were convicted of assault, bodily injury, family household, and cause number 669877. Who were you on probation for out of that cause number? What is their relationship? Can somebody look that up for me? Cause number 669877. It's a county court cause number, and see who the complainant was.
Cheryl Simmons.
Cheryl Simmons.
Yes.
So the same person. What is your issue with your mom? I don't understand people who hit their mothers and their parents. As you know, I'm from the old school of parenting. That most definitely would not have been allowed. And there are many things that I cannot say, but I don't know if, well, I do know. If I would have hit my mom, well, let's just say I would not be here as judge now. But people would probably be saying, oh, we remember Stephanie. She was such a nice little girl. So why are you hitting on your mom? And this is not the first time. There has to be a reason for it. Why do you think it's okay to hit your mother?
I mean, I could sit here and say I didn't, but I mean, I said no context, so.
Well, no, I mean, you've done it before in the past. So I'm trying to figure out why you're hitting on your mom. Why do you think that's okay? Oh, you want a jury trial?
No,
Mhm.
I'm just answering the question.
Well, we have 2 cases with you involving your mom. So you're saying on both occasions, you never put your hands on her. And the fact that they're saying that she's bleeding from the lip, that's just, I don't know, something she did to herself. All right. And it says here, you hit her with a closed fist, splitting her upper lip, causing it to bleed and swell. It says suspect grabbed victim's left upper arm with his left hand, holding her in place, and then punched her in the mouth with closed fist. And all of this because you wanted her to drive you to the store, and she said, no, walk. I don't know what people, in this day and age, people act like children can't ride the school bus. They got to have a nice car. People can't walk to where they need to go because it's embarrassing, or get on the via bus because it's embarrassing. If you don't have a car, can't afford a car, get a car, you walk. All right, are you employed? Would that be at Babies? Are those burgers better than Chris Madrid's? I'll see, you supposed, if you work there, you're supposed to say most definitely, but
Chris Madrid's is hard to beat, Judge. He's trying to be honest. He's under oath. He's trying to be honest.
okay. All right, do you have any children? What are their ages?
7.
And who does your child live with? Do you see your child? Do you pay child support?
Yes.
All right, and I ask these questions because part of your conditions on probation, which sometimes people don't read all of the conditions, even though probation, I know, goes all of the conditions with you. Part of the conditions of probation automatically is supporting your dependents. All right. All right, 6 years deferred adjudication. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. No unsupervised contact with minors. No contact with Cheryl and Simmons. And that's with 1 M. There's an affirmative finding of family violence. I'm going to want regular reporting by Zoom or in person, regular UAs. I'm going to want field visits 2 times per month until further notice. The BIPP course, anger management. Probation, is there anything else he needs?
Connor, did you mention community service hours?
Let me do that. There's to be no harmful or injurious contact with Ronald Simmons. 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get that, but if you do, 40 of those hours will be waived. Parenting classes with triple P. Anything else, probation?
The remaining of the community service hours we waived after the parenting class.
Yes.
Nothing else, Your Honor.
Anything else you need from the court in order to be successful? I'm sorry. Showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it? Because this is plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. And because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Good luck to you. You only get one mom in this world. And you know what? The way you're treating your mom, you're asking for your son to behave in that same manner. And your son may end up going before a judge because they're looking to you and you're educating them on how to solve problems. And this is not the way you do it. Do you understand? From here on out, everything you do, you need to ask yourself a question before you make a decision. Is this something that could potentially result in me going to prison for 10 years? And if the answer to that question is maybe, I don't know, you shouldn't do it. You understand? Good luck to you.
Thank you, Judge.
You're welcome. John Marino. Come forward. All right, good morning.
Here for Mr. Martinez.
All right, what is happening on this case?
I believe this is the first setting, Your Honor, and we need to reset to get medical documents as well as some other discovery and statements contact the complaining witness.
All right, Ms. Ferguson, on John Marino, state, is 45 days enough time for you all to get the discovery with the medical records?
I'm never gonna object to more time, Judge, but we actually have the records. We just need to upload them. They're in the file. Yeah.
Okay, so thank you.
But if you want to give us a 45-day reset.
I'll give you 45 days. Ms. Ferguson, can I have a 45-day reset? And at the next setting state, I need you to be prepared to make an offer and the discovery acknowledgement.
Sure, Judge.
Thank you, Your Honor.
I'm sorry, when? All right, April 10th. All right, once you sign the reset form, you're excused.
Thank you, Your Honor.
You're welcome. Thanks for dressing appropriately for court.
Thank you, ma'am.
All right, who is here on Jace? Why am I back for JC Laday?
That was a plea.
Yes, I'm like, it's back in my stack. All right, who's here on Gina Garcia? All right, come forward. There's no application. After Gina Garcia, we have Alexander Naran, Andrew Pena, Roger Gonzalez, Mario Uridalis.
Mr. Judge, she is not Gina Garcia, the court clerk. You remember Gina Garcia?
Yes, I do. Court is calling 2022 CR 11627, State of Texas versus Gina Michelle Garcia. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Charles G. Richardson.
Are you Ms. Garcia? Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the stay is in compliance with discovery. Ms. Garcia, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, we're waiving the enhancement paragraph.
Any objection?
None, Your Honor.
Ms. Garcia, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with unauthorized use of a vehicle? The range of punishment for that offense is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent, was legally sane at the time of the offense?
She is.
Ms. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea? Satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, punishment is to be assessed at 6 months in the state jail facility. Did you understand that to be the plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
I know, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
State offer states to the one in all attachments.
No objections, Your Honor.
Ms. Garcia, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, I did.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. And the court will find you guilty. Are we proceeding with sentencing?
You're.
Court will follow your agreement, sentence you to 6 months in the state jail facility, give you credit for any time served. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand? All right, we can go off the record. You're gonna have to start doing things differently. Otherwise, you're gonna end your in and out of prison and in and out of the Bexar County Jail or other jails, okay? Good luck.
Good to see you.
Who's here on Tony Banks? Yes. I'm sorry, yes, sure. All right, and everyone, I know I skipped over a couple of people because this wasn't next in line, but the court reporter needs to take a short recess, so that's why I did it. All right, what is happening with Mr. Banks?
Judge, talking with Mr. Banks, I've got to do some legwork before we're ready to decide which way this case is going to go.
All right, does he have a warrant? I mean, if there is, we'll see what's going on. But there, I have in here a no-show on November 28th. We're gonna check and see. He does not? Okay. All right, what lead work are you working on?
Some suppression type issues.
All right, state on Mr. Banks, who's with Criminal Trial Division on this. It's on page 12.
I can take a look at it, Judge. Have you conferred with anyone today?
No.
Okay, I don't think we've conferred, but.
All right, have you conferred?
No, Judge.
All right, you all need to confer. I require it.
Okay.
William Chapman. All right, come forward. What is happening with this case?
We called a motion to reinstate bond.
All right, so just give me a moment on this because I skipped over other people in line.
Okay.
Because I didn't know this was one that would need a reporter, so.
I see.
Yeah. All right, I think Mario Uridalis, who's on here on that one?
I'm here for Your Honor.
All right, does that require a record? Yes, it does. Christopher Reyes,
Here, Judge.
does that require a record?
Yeah.
All right,
Listen here to announcer.
Okay. All right, where's Christopher Reyes?
Here, Judge.
All right, so what is happening with this case?
Judge, I just found out just a little bit ago that there may be 2 additional at-large cases that are pending with the DA's office. I want to have a chance to look into that, to get the discovery for those. Because it's my understanding they could be used in punishment. I was told to bring a flash drive and that'd be the fastest way to get it. It's not quite here from the police agency yet, but they have quite a bit of information.
All right, so what are these 2 new at-large cases?
A burglary of a building, I believe, and a criminal mischief.
Okay. State, when are you gonna have that information?
I'm not sure, Judge. As best as I can tell, it was a JAN that was created by the agency, so I don't think they've actually sent us the physical file over yet.
Okay.
So I don't think anything's been created. No one's been assigned to review the case. So it's hard to say at this point how long it'll take.
All right, so I'm giving you guys 45 days. So
Okay.
everything needs to be where it needs to be.
And we're planning, obviously it would be 404 evidence potentially for punishment. So we're planning to give the defense a copy via flash drive, even though the actual case may not be filed at that point.
Okay. All right, Ms. Ferguson, I need a 45-day reset on Mr. Reyes. April 10th.
Okay, Judge.
All right, and Sharon says hi, by the way.
Oh, okay. All right.
All right.
Judge. Thank you.
Thank you.
You're welcome. Okay, thank you so much. Thanks. All right, who's here on Naron Alexander? All right, come forward. Court is calling 2022 CR 6424. State, oh, he needs to be in the middle, counsel. If y'all just slide this, oh, and counsel, you're over here. Court is calling 2022 CR 6424, State of Texas versus Naron Alexander. Could I have parties announced for the record for the state?
Nicole Thornborough for the state.
Defense.
Joy Contreras for the defense.
And are you Mr. Alexander?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
We did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Alexander, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it?
Yes.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, we are. Your Honor.
Mr. Alexander, I'm showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Do you understand you're being charged with an insurance fraud? I believe this is up to $30,000 as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights? Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Alexander, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 1 year in the state jail facility. There's a $2,000 fine, no application for deferred adjudication. I'm sorry, just one moment. When mom calls, you need to answer.
That's right.
All right, according to the plea bargain agreement, a punishment is set be assessed at 1 year in the state jail facility. There's a $2,000 fine. State recommends community supervision. There's to be restitution of $13,631.41 to Cigna, CIGNA. Did you understand that to be the plea?
Yes.
Defense?
That's, I understand.
State?
Yes.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
None apply, no.
Next, I'm showing you outside the plea bargaining agreement, the state is requesting that your community supervision be for a term of 3 years, and there be 180 hours of community service restitution. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the plea?
State offers states exhibit 1 and its attachments.
No objection.
Mr. Alexander, I'm showing you what's titled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence. The court will sufficient evidence to find you guilty. The court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor. No.
All right, so with regards to the restitution, is 3 years enough time to repay the restitution?
I believe it is, Judge. He's part of the NFL settlement. And it looks like he's in line to receive a settlement within the 3 years.
All right, so.
Yeah, but if there's a problem, we'll return. I don't think they will do that.
All right, the court will sentence you to 1 year in the state jail facility, suspended and probated for 3 years. Based upon what I'm reading, are you currently working or no?
Disability.
Okay. Proof of disability within 30 days. Restitution to Cigna for $13,631.41. Regular reporting by Zoom or in person. Regular UAs. 180 hours of community service restitution. I know you're receiving disability. If he can't perform community service hours because of his disability, he'll need to provide proof of that to probation. Otherwise, he can pay for the community service hours.
He actually does a lot of community outreach that I guess this is not strenuous. So
okay.
Maybe he can arrange to have that applied.
All right, probation. He's allowed to do community outreach for his community service. You may need to make sure that you tell them exactly what that is. All right. Probation, is there anything else he needs?
Your Honor, are you waiting 40 for the COVID vaccine?
No, he can just do the 180 hours.
Okay, do you want field visit?
We'll do field visits one time per month for 2 months. If there are no issues, then there's no further need for field visits.
That's all.
All right, is there anything else you need from the court to be successful?
Judge, did you impose a fine?
Thank you. $2,000 fine. And that will be probated. Is there anything else?
No, thank you, Your Honor.
All right, anything you need from the court to be successful? Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to consult with an attorney. Do you understand?
Yes.
All right, we can go off the record. So what team did you play for?
Denver Broncos in Houston.
All right. Do you get upset when you have fans watching and they think they could have called better plays or done something differently?
Of course.
Oh, okay, just curious. But that's not for me, that's for everybody else. So when I complain about it, it's okay. All right, well, good luck to you. Thanks for dressing appropriately for court.
Thank you, ma'am.
All right, probation will go over conditions, then he's excused.
Thank you, Your Honor.
Thank you. All right, the next person up is Andrew Pena. All right, are we here for a motion to revoke? What are we here for?
Yes, Your Honor.
All right. Court is calling 2020 CR 8246W State of Texas versus Andrew Pena. Can our parties announce for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Matt Stohansky for Mr. Pena.
All right, so I'm being told that a motion to revoke has been filed today.
Yes, ma'am.
Are you all going to proceed even though the motion was filed today?
It was amended today.
right.
We're ready to proceed or.
Okay. All right, Mr. Pena, I'm showing you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that document with your attorney? Did you understand it?
Yes.
All right. Are you the same Andrew Eugene Pena who was placed on deferred adjudication in 2020 CR 8246W for the offense of possession with intent to deliver a controlled substance, penalty group 1, 4 grams to 200 grams
That's right.
on October 21st, 2020 for a period of 5 years. Is that you?
Yes, Your Honor.
All right, state.
Violating condition number 2, on or about the 7th of February 2023 in Bexar County, Texas, the defendant, Andrew Eugene Pena, to then and there illegally use a controlled substance, namely amphetamine, in violation of condition number 2.
How do you plead to that? True or not true?
True, Your Honor.
Your Honor, state waives all the violations.
Any objections?
No objection. Your Honor.
All right, did you understand by pleading true to violation of condition?
Yes, Your Honor.
Just one moment, off the record for a second. This should be just straight possession, according to the order. And according to the court admonishments the court has. So he was placed on deferred adjudication for possession of a controlled substance, penalty group 1, 4 grams to 200 grams. Is there a motion from the state with regards to the motion to enter adjudication of guilt?
I think see the. Judge, the state makes a motion to amend the motion to enter adjudication of guilt to change it to just possession. It's on here, it says possession with intent to deliver.
All right, any objection? All right, Mr. Pena, do you understand that's a substantive change to the to the motion to enter adjudication of guilt, and your attorney could have more time to prepare. Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to continue?
You want to do this today or you want to come back?
I can come back another day.
Oh, well, you have a judge's warrant, so either way, you'll be coming back by bus. So you will not be leaving the courtroom today. So we can do this now, or you can come back on another day. Which would you prefer?
Just today now.
All right. Are you the same Andrew Eugene Pena, who was placed on deferred adjudication in 2020 CR 8246W for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on October 21st, 2020 for a period of 5 years? Is that you?
Yes, Your Honor.
All right, state,
Your Honor.
if you reread, please.
Sure. Violating condition number 2, on or about the 7th day of February 2023 in Bexar County, Texas. The defendant, Andrew Eugene Pena, is then and there illegally used a controlled substance, namely amphetamine, in violation of condition number 7.
How do you plead to that? True or not true?
True, Your Honor.
All right, state.
Your Honor, state waives all the violations.
Any objections?
No objection. Your Honor.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years and prison and a $10,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, Your Honor.
Court will find violation of condition number 2 true. Is there an agreement?
No, Your Honor, state recommending safety.
All right, defense, what are you requesting?
And Your Honor, we're asking that he be allowed to go to some inpatient treatment. And if the court remember, he was in an inpatient treatment in Austin. And you said he needed back here for this. He wasn't going to go to that one. We have some documentation Mr. Pena would like you to have as part of your consideration. He has done 30 meetings in the last 20 days. May I approach?
Yes.
We also have the discharge. He was discharged from the program that he was in because he had to come here, but he was going there.
All right, any objections to the court reviewing these documents?
No, Your Honor.
All right, you may continue.
Yes, Mr. Pena has a long history of mental illness. He was subjected to a sexual assault in the Army. He has tried to commit suicide. He is suicidal quite often. He has a very poor relationship with his brother, who is one of his trigger points. There's a lot of issues. Their father is elderly, and he triggers Mr. Pena to go into these episodes. And we're asking that he be allowed to re-enroll in the outpatient program that he was in and issue some sort of no contact with his brother.
All right. And is there anything else?
No.
All right, Mr. Pena, you've been here before the court. I think this is your third occasion for using. I'm going to give you a choice. If you wish, I can send you to prison. Or if you wish, I can send you to drug treatment. But either way, you're not leaving court today. So you can either, I'll have you taken into custody. We'll do a referral to felony drug court. If felony drug court does not accept you, then you'll be going to safety. Or if you want, I'll sentence you to 3 years in the prison. And the reason why I'm at the 3 years is based upon what your attorney has presented to me.
With the credit for all the time that he's been in and the programs he's completed.
If he successfully completed programs, yes, he'll receive credit for that, but it has to have been inpatient.
May I have a moment?
Yes.
Mr. Pena is would like to, so I'll let him take it. Sorry.
All right. Yes, Mr.
Ask
Pena.
him the question.
Your Honor, I want to, I will accept 3 years and take a seat.
All right. And you'll get the trial court certification.
Yes, ma'am.
And Mr. Pena, I will tell you, if felony drug court were to accept you, that's a great program.
We're already gonna make that out.
All right, here's the thing, Mr. Pena, you cannot write your own program. If everybody could write their own program, we wouldn't be here. I know there are different treatment facilities where people would prefer to be there, or different programs they would prefer to do, but you can't write your own program.
Could I ask the court case number quick?
The case number is 2020 CR 8246W. All right, Mr. Pena, are you asking to be sentenced to 3 years in the prison?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor. That's what it should be right now.
All right, the court is finding violation condition number 2 true. The court will grant the motion. Find you guilty, revoke, sentence you to 3 years in the prison, give you credit for any time served, and credit for any time served in a successful completion of any inpatient treatment. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, good luck to you, Mr. Pena. Roger Gonzalez. All right, probation, this is no application. Court is calling 2022 CR 8642, State of Texas versus Roger Gonzalez. Now, party announced for the record for the state.
Daniel Escobar for the state of Texas.
Defense.
Anthony Miller from Mr. Gonzalez.
Are you Roger Gonzalez?
Yes,
Counsel, have you received all the discovery in this case, and did you review it with your client?
we have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Gonzalez, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, the state's proceeding on count 1 and waiving count 2 and 3.
Any objection?
No, Your Honor. I believe they're also waiting the repeater. Too.
Yes, Your Honor, the state's also waiving.
All right, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand what you're charged with is possession of a controlled substance penalty group 1, 1 gram to 4 grams, that's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, he is, Your Honor.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea?
No.
Satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to plea, punishments be assessed at 2 years in the prison, and there are no applications. Did you understand that to be the plea? Defense?
It is. Your Honor.
State?
Yes, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged in count one, how do you plead? Guilty, not guilty, or no contest?
No comment.
State any evidence?
State overstates exhibit one in all attachments.
Any objections?
No objection.
All right, state you may be excused. Mr. Gonzalez, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits one in attachments and review the same. After reviewing states exhibits one and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are we proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
We're just asking the court to follow the plea bargain. I know Mr. Gonzalez is trying to put this matter behind him, Judge, and move forward.
All right, Mr. Gonzalez, it appears that you have a drug problem. If you would like, I can have you referred to the therapeutic community. It doesn't increase the length of the time that you've been in prison, but that may be something that could help you. Do you wish to have that or no? I'm sorry?
Just to go, same paper number.
Okay.
What she's asking is that TDC offers a therapeutic community, and would you like to be referred to that? Oh, yes.
Okay. Do you have any children?
Yes.
What are their ages?
13, 12, 8, and 4.
When's the last time you had contact with them?
It's been
It's been what?
over a year.
All right, and I'm sure the reason that is because you're not being upstanding role model. You're gonna have to change your life if you want to be in their lives. You understand?
Yes, ma'am.
All right, the court is going to sentence you to 2 years in prison, give you credit for any time served. There's to be no contact with the Ever Clean, EVERKLEEN motel located at 1306 Roosevelt Avenue, San Antonio, Texas 78210. Therapeutic community is recommended. You're still going to have to ask for it, even though I'm recommending it. And no contact with Mario Castillo. Going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. All right, good luck to you. Who's here? Thank you. Who's here? Mario Uridalis? Oh. I see, I'm the person who didn't take this sentencing, so that's why. So before we go on the record, we're just doing a sentencing on the 2022 CR 10253.
That's correct, Your Honor.
And then what is happening with the 2019 case?
I believe everything was completely taken care of with.
I think it's supposed to be a TIC judge, but I'm not the one that did the original. It
was all, everything is getting taken care of.
Okay, let me look at the,
Thank you.
yes.
Thank you, Judge.
Okay, so it's not written in here. Are you all sure the other case, the 2019?
Yeah, we wouldn't be moving forward with the sentencing if we hadn't taken care of everything that was outstanding.
And Judge, look, give me just one moment, just.
All right. Because it's not listed in the plea paperwork. And then that other case is a motion to revoke. So something's even, it's not a TIC, he's on probation for that.
Then it might be a revocation and just
Okay.
current. I'm not certain either, Your Honor. Look, they check their records.
All right. So did
You
y'all
were on
need to-
probation, right?
All right, are you Robert Anthony Uradala?
No. This is Mario.
Ah, okay, there's no other case then.
No. Just the one.
I was trying to look it up, Judge. I was like, wait a minute.
Problem solved. All right, the court is calling 2022 CR 10253, State of Texas versus Mario Uradales. Can I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Todd Lessert for the defense.
And are you Mr. Uradales?
Yes, ma'am.
All right. You were scheduled for sentencing here on February 23rd, but you did not show. State, are you still proceeding with the agreed plea?
Yes, Your Honor.
All right, according to the plea bargaining agreement, your punishment is to be assessed at 18 months in the state jail facility. The court will find you guilty, sentence you to 18 months in the state jail facility, give you credit for any time served. Going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, Mr. Uradales, we're off the record. You're gonna have to make better decisions in your life. All right, how's the drug issues coming along?
I just slipped. I was doing good when I first got out. I got my license for the first time I ever had my license. I was working, so.
Okay. All right, so if you want, I can ask that you be referred to the therapeutic community. It doesn't increase the length of time that you're in custody. But if that's something you feel like you need and you want help with that, to be prepared once you re-enter society, I can order that.
Yes.
Okay, so we're gonna add the therapeutic community. You're still gonna have to ask for it though, okay? All right, good luck to you. Yes. We're gonna follow our Festivus rules. Oh, well, get the plea paperwork for us, people.
But I don't think they will be in.
Okay. Who's it on?
Oh, I don't.
Okay. All right, who's here on Robert Anthony Uradales?
Good to see.
All righty,
Mr. Uradales is custody.
yes.
And so, it's,
Oh, come down. Where is he?
oh, no.
Oh, he wasn't brought over.
No,
Okay.
it's off docket, Judge. I visited with the state about a possible bond, and we've got an agreement subject to the court's approval.
Oh, this is off docket?
Yes, Judge.
Okay.
Mr. Uradales is in custody, and so it's a motion to enter an adjudication.
All right, so I have August 19th, 2019. I'm sure something has happened since then. So a motion to revoke was filed, correct?
It was, Judge.
Okay. All right, Ms. Ferguson. We're gonna need a setting on Mr. Uradales for MTR. Do you know if this is gonna be contested or not?
It's not gonna be contested, Judge, and he's got some time in. He's got a new misdemeanor that I think we need to plea to, but so we're already crafting out the possibility of a result of it.
All right, Ms. Ferguson, it's off docket 2019 CR 4223. And then after this, it's going to be William Chapman. All right, your court date is going to be March 28th. But if you want it moved up sooner, then let us know.
Okay, and then the.
Hmm.
So we're moving on one, so,
Yes,
okay, thank you, Judge.
you're welcome. Thank you. Who's here on William Chapman? All right, if you come forward. And where's Mr. Chapman?
He's here, Your Honor, stepping out from the box.
All right, I know you all are saying that, is there an agreement on this to reinstate bond or no?
There's not.
Not.
All right, so. All right, court is calling 2022. CR 11445. Well, just 1 second before we do this case. State, do you have witnesses prepared to testify?
We don't have any.
All right, so we're going to recall this. State, you need to make sure you have your witnesses present to testify. So Ms. Ferguson, what date? It's a motion to reinstate bond. Unless the defense wishes to proceed without, unless the defense is going to waive confrontation clause.
I'll wait, Your Honor.
All right, Gina, waive confrontation.
Yes.
All right, if you all have worked out some sort of plea agreement, even though you're waiving confrontation, that doesn't necessarily mean that the court is going to follow your agreement.
We don't have a plea agreement. It's just, we're just trying to get the bond reinstated.
Okay. All right, court is calling 2022 CR 11445, State of Texas versus William Chapman. Can our parties announce for the record for the state?
Ruben Herrera for the state.
Defense.
Tracy Franklin for defense.
All right, the court, Magistrate Judge Jansen ordered the defendant remanded without bond for a violation of GPS inclusion zone. Have both parties had a chance to review the updated letter?
Yes, sir.
Yes, Your Honor.
All right. And defense, for the record, are you waiving confrontation?
Yes, Your Honor.
All right, state.
Your Honor, the state's objection, first off, is based on the nature of the allegations in the case. But secondly, Your Honor, the motion is based off of a violation of the defendant's GPS inclusion zone, stating he was out past the time intended allowed, since he is allowed time for work. I've spoken with counsel, Your Honor, and while the defendant has presented a claim that that the violation occurred based on an accident involving a vehicle that he was in while out for work, the defendant has provided no evidence to substantiate that story, Your Honor. Any evidence that has been presented by the defense does not directly correlate to the defense's allegations. Based on that, Your Honor, the defendant was admonished as to the bond conditions that were set on him when he was magistrated, fully aware that he was to be at certain places at certain times to comply with his bond conditions. And based on that, Your Honor, the state would object to reinstating the defendant's bond.
All right. Defense.
Yes, Your Honor. The violation report does state that Mr. Chapman was located at, it gives an address of 15111 Main Street in Lytle, Texas, and lists that location as an outlaw bar and grill. Mr. Chapman does state that he was working that day near that area. And in fact, the address that he was at on that date was 14929 Adams Street in Lytle, Texas. And I do have an exhibit that I did share with the state showing how close the two addresses are to one another. They're 2 minutes apart. Mr. Chapman was there, in fact, on assignment from work. And he was there to get an estimate. He works for a man named Rudy Ramirez. They do tree trimming. He was there to get an estimate on how much it would cost to trim the trees in that area. When he did go to get that, he thought he could get that estimate done and be home by 8 p.m. He left it around 7 p.m. He is required to be home by 8. He did get into a car accident in his brother's vehicle. Unfortunately, the people that he was in an accident with did not want the police called. They're not United States citizens. The car was undrivable. I do have another exhibit with photographs of the car. The car belongs to his brother. His brother did go the next day to have the car towed away from the scene, did send these 2 photographs of the car. So no accident report was made. Mr. Chapman's stepfather did pick him up that evening after the accident, and a few hours later, he's, Mr. Chapman there's no direct evidence to show that he was actually at the bar. He wasn't anywhere near the complaining witness where he's not allowed to be. And there are no allegations of any alcohol use or anything like that. So for those reasons, we would request that his bond be reinstated so that he can be out of jail. He does have a special needs 5-year-old child at home. His wife works full-time. They have 2 other children. So he's just asking to go ahead and be released to help her out. And we are expecting this case to go to trial, Your Honor. So we're hoping that he can be out for the duration until we can get it on the trial docket.
All right, so this is the information that the court is going to need provided for us to make a decision on this. One, his employer who sent him out, are you able to get them to appear by Zoom so that you testify for the court, or either in person?
Do you think that
You'll probably do Zoom.
That's all right. So all right, so what we're gonna do then is we'll recall it for tomorrow. But he needs, his person who's gonna zoom in, they need to zoom in by 9 because we may be in jury trial. So just make sure, and then the court will make a decision on your request to reinstate bond.
Yes, Your Honor, and would you like to review these exhibits at that time?
Yeah,
tomorrow?
well, if you, nobody has any objection, if you want to leave the exhibits with me, sure. Because I know they're not being offered in the evidence, they're just going to be received. And then I'll make sure that these are reviewed before tomorrow.
Thank you, Your Honor.
All right, and State, did you have a chance to review the?
I did pretty good.
All right, so we're going to come back tomorrow at 9 a.m. and I'll make a decision on it at that time. And counsel, Ms. Ferguson will later in the day give you the Zoom link for tomorrow.
Okay.
All right, thank you. Who's here on Tony Banks? All right, what's happening with this case?
The state needs a little time to contact the complainants. We may be able to resolve it. So.
That's correct.
All right, and do you have all the discovery?
Yes, ma'am.
All right, Ms. Ferguson, I need a 30-day reset on Mr. Banks. All right, we'll be back on March 28th.
Thank you, ma'am.
All right, Ms. Ferguson, we'll give you a reset form, then you're excused. Who's here on Mark Anthony Ramirez? And this is for probation.
Yes, it is.
All right, court is calling 2023 CR 1266, State of Texas versus Mark Anthony Ramirez. Could I have parties announced for the record for the state?
Jason Jorgens for the state.
Juan, attorney for Mr. Ramirez.
All right, and are you Mr. Ramirez?
Yes, ma'am.
Counsel, have you received all the discovery and that you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ramirez, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we have a small amendment, and I apologize, I didn't get a chance to talk about it with the defense attorney. The indictment alleges that the prior felony offense was PG 1 4 grams to 20 grams. We would move to amend that to read to 200 grams.
We have no objection. Your Honor.
All right, Mr. Ramirez, do you understand that's a substantive change to the indictment?
Okay. Yes,
Do you understand that?
yes, ma'am.
Do you understand that your attorney has 10 days to prepare for trial? With a substantive change to the indictment? Knowing that, do you still wish to continue?
Yes.
And counsel, are you waiving notice?
Yes, Your Honor.
Mr. Ramirez, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand that you're being charged with felon in possession of a firearm? That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter a plea in this case? You're gonna need to speak up.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as the factual understanding of the charges against him?
In my opinion, he does, Your Honor.
Do you believe he's currently competent, was legally sane at the time of the offense?
In my opinion, yes.
Mr. Ramirez, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 5 years in the prison. There's a $1,500 fine. State recommends community supervision. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 5 years. There be a TAP evaluation, 200 hours of community service restitution, and the destruction of the firearm and regular UAs. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. The state offers Exhibit 1, the defendant's waivers and stipulation of evidence.
No objection, Your Honor.
All right, state your excuse.
Thank you, Your Honor.
Mr. Ramirez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are we proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Just Judge, he wants him. He understood that it was kind of a stupid thing that he did. He is a hard worker. He does flooring. In addition to doing flooring, he's a very skilled horseman. He does work for different individuals that I know and perhaps the court knows. Alvarado, Judge Michael Ramos. He's involved with the Charter Association. He grooms their horses. He's also a farrier. He takes care of their horseshoes, all kinds of things. So he's understands it was not a very
wise thing that he did, but he wants to continue doing his work with a foreign company, continue doing his work with the Charter Association, and he would like an opportunity to be placed on probation.
All right. Okay. All right, Mr. Ramirez?
Yes, ma'am.
If you're drug tested today, what are the results going to be?
I'll be great.
For what?
No one.
And what else?
Yeah.
How often are you using that? I mean, it has to be often because you're going to be positive today, which means there's some issue with you with meth because you knew you had court today and you still use. So how often are you using meth?
At least twice a week.
For the better part, he's been in jail up until last Tuesday, Judge, so he's been incarcerated at least for 2 months, 2.5 months.
All right, who is Melissa Romero?
She's my girlfriend.
Are you all still together?
Yes, ma'am.
Do you live together?
No, she has her own place. I mean, we're gonna move in together.
That's something you probably shouldn't do. Because is she using?
Not that I know of.
I mean, we usually know if the people we're in a relationship are using. You probably need to get your own place because you're gonna need to take care of you first. And then if she's a person who you think you should be in a relationship yet with, someone who's not using, then you can do that, okay?
Yes, ma'am.
All right, so this is what the court is going to do. The court is going to sentence you to 5 years in prison, suspended and probated for 5 years. There's a $1,500 fine that will be probated. Proof of employment within 30 days. There's to be no employment as a home health care provider with minors. 200 hours of community service restitution. Do you have any children?
Yes, ma'am.
What are their ages?
24, 21, and 17.
All right. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. I'm going to do a referral to felony drug court. Felony drug court may not accept you because of your priors, but you need to be 100% honest with them because they do consider you on a case-by-case basis.
Sure.
If he's not accepted into felony drug court, I'm going to want a TAP evaluation. And we'll start off with intensive outpatient treatment and 90 sober meetings in 90 days. Destruction of the firearm. Where are you living now?
My mother's.
All right, there's to be regular reporting by Zoom or in person. You need to remain with your mother, but realize you're not an adult because you're living with your mom and her rules apply. But I don't think it's good for you to reside with Miss Romero until you're on your road to sobriety, okay? So defendant is to reside with his mother. What's your mother's name?
Linda Ramirez.
All right, Linda Ramirez. No residence with Melissa Rangel Romero. I'm going to want the UA hotline testing for at least a week until he gets into felony drug court. Field visits 2 times per month until further notice. And probation, if you want the field visits to substitute for reporting, it can. Probation, is there anything else for him?
No, Your Honor.
Is there anything else you need from the court to be successful?
No, ma'am.
Tanya, what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? Did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, ma'am.
All right, good luck to you.
Sure.
Yes. Who's here on Pedro Sanchez? All right, what is happening with Ms. Sanchez?
Mr.
Mr. Sanchez?
So the state tendered an offer. He's got a case pending out of County Code 11 with a different complainant. We were asking for time. I think we're gonna have this case worked out to as a plea, but we need to get confirmation that I guess the complainant in that case is okay with the resolution as well.
Okay, because today is his plea deadline date.
Yes, Judge. And so I guess what I'm asking the court can give us a brief extension of the plea deadline. I think we'll have it worked out.
All right, Ms. Ferguson, can we recall this in 2 weeks, please?
Thank you, Judge.
All right, let me see what date.
March 9th.
All right, March 9th, that's the last extension for plea deadline date. Ms. Ferguson will give you a reset form.
Thank you so much,
Thank you.
Judge.
Terrence Reed. All right, so what is happening with Mr. Reed?
Your Honor, I just conferred with, Vice Counsel and made an offer today. But I think there's other, things that defense counsel would like to get done on their side, which, I'll let Mr. Ford address that.
All right, counsel.
No, Judge, this is the first time Mr. Gina and I actually got to confer about this. He's no attorney on this case. A couple of little issues. He gave me his offer today. I've already tendered it to Mr. Reed. He said no on the offer as of now. Asked me if I'd give him a counter offer, but at this point in time, we're not ready to give him a counter offer, so we just have a trial setting on that.
All right, so I always give plea deadline dates, as you know, counsel. So I'm gonna give you all a plea deadline date of 30 days. And you all can confer off record if there are counter offers or whatever y'all want to do. Ms. Ferguson, I need a 30-day reset. All right, so on March 30th, Mr. Reed, at that time, you need to let the court know whether or not you're accepting any offers. And then if the answer is no, then your plea deadline date will have expired and the next setting will be a trial setting.
And we'll make sure any other group negotiations or offers will already been done.
Okay, and then with regards to the 2022 CR 7439, I'm assuming 2022 CR 0903 is controlling.
The murder, Your Honor, I'm sorry, I don't know the numbers also.
Oh, okay, no problem.
But the Agasold and the murder were at the same time.
Okay.
And as of right now, we'd be just trying to murder.
Yeah, and I believe he's been indicted on another case also.
Let me see.
Check. I have it in.
There's a. I don't see any, unless there's a new one. I only see this one.
No, it's just.
It's just those two.
Yeah, it's just these two. That's correct.
Okay, then that will be all.
Thank you.
Thank you, Judge.
All right, thank you. Thank you. Have a good day. Yeah.
Sorry.
I've been waiting on Jason all day.
Hey, I was here, but
I know there are a lot of
I
laws in
hate
there.
leaving, but it was one of those ones again, you know.
Yeah. So is that it for us, everyone? Because the other people who were not here, they'll need to come back. So that is Justin Stegmeyer. Arturo Aguilar with Lefton.
I don't know who this guy is, thank you.
I'm sorry, sir, what's your name? Oh, we're getting to you, just a moment. Oh, no problem. And then,
She's on vacation. She's got to get the call after March.
all right, let me see. Okay, what date for Arturo?
We did 16.
Oh, I'm sorry, it's Aguilar, sorry. The 16th? All right, and then we have Stegmeyer. Okay. Then we have Golfo. Xavier Garcia, make sure his attorney shows up because we need to know where Mr. Garcia is. So let's recall this for tomorrow as well. Yes, because I need to speak to the attorney on that one. All right, and then we have Cardenas, Fabian Cardenas. If you come forward. And that's with Amy Owen. All right, recall for tomorrow. They'll give you a reset for tomorrow. Don't leave without your reset form. All right, Patricia Lopez.
She did not come in.
All right. That will be a bond forfeiture. And we're gonna go, let's go on the record on this. Court is calling 2022 CR 11172 and 2022 CR 11230, State of Texas versus Patricia and Lopez. Can I have state announced for the record?
Jason Garahan, Your Honor.
All right. This hearing was scheduled at 9 a.m. and it's 1:12 p.m. Defense counsel did not show. The defendant did not appear. Deputy Laura, did you make an announcement for Ms. Lopez?
Yes, Your Honor, I did, and she did not respond.
All right, state.
State's asking, requesting a bond forfeiture, Your Honor.
That will be granted. The defendant will be remanded without bond in each cause. If defendant makes an appearance, the court will reconsider. All right, and then we have Hannah Smith.
Is she not in jail?
No, she's in jail.
Okay, that's what I thought. Okay.
All right, Ms. Ferguson, if you'll recall that for tomorrow. It says on here, this was supposed to have been transferred to the 186.
Judge, that's the one that was Paul Donaldson and this Hannah Smith were being transferred for those ones that they were transferring to you.
Mhm.
And then they decided not to transfer those cases. Is that right, Norma?
Yeah.
And so then they transferred them back to you.
Okay.
So the family is very upset.
Norma,
Victim's family, that is.
Recall this for tomorrow, please. All right, and then we have Carlos Madrigal. And I'm trying to find that on the docket.
That was moved up from Thursday, Judge. That was for the attorney to come in. It was a motion to amend 5 conditions.
All right.
And you asked for us to get in touch with the complaining witness to see when she can appear to be aware of the meeting.
Okay.
We did speak with her, Judge. She works 5 a.m. to 5 p.m. during the week. Is only the
All right, so Ms. Ferguson, if we can recall this for Sorry, I know it's against the rules. But if we can recall this for Friday, please.
As long as it's family violence.
Okay. And so that's Madrigal.
That's why she was
I
saying that.
know. I'm so sorry. I remember my mind's a steel trap. So, but you know what? We'll do that one and that will be, that's all that's there. And then we have Anthony Miller.
He did not come in, Your Honor.
All right. Court is calling 2022 CR 3230, State of Texas versus Anthony Ray Miller. Could I have state announced for the record?
Jason Garahan, Your Honor.
All right, this hearing was scheduled at 9 a.m. It is now 1:15 p.m. Defense counsel did not appear and the defendant has not appeared in the courtroom. Deputy Lord, did you make an announcement outside?
Yes, I did, Your Honor.
State?
State's requesting a bond forfeiture, Your Honor.
All right, that'll be granted. The defendant will be remanded without bond. If the defendant makes an appearance, then the court will reconsider. And with that, I think we're done. We'll be back on